Lordship, one matter fixed by the this honorable court, Lordship, because his daughter's marriage is fixed on 5th, but it is not in the list, Lordship. Because of that reason, Lordship may take up tomorrow or day after tomorrow, like that, Lordship, because marriage is fixed on 5th. Because of that reason, fix the matter on 1st of May. It is not in the list, Lordship.
It has not come in the list.
List already published. That is why, Lordship, if possible, if not possible tomorrow, then day after tomorrow, it will do, Lordship.
Day tomorrow is
Because of that reason, Lordship.
Second.
Lordship. Obliged to.
May it please your Lordship. Lordship, I would to mention for listing a bail application, Lordship. Petitioner is behind the bar from last 2 and 7 months, Lordship. And the case is still in a appearance stage, Lordship. So kindly this
There are matters are actually what had happened. We have deferred some matters for due to some reason. So most of the matters have been fixed on 5th, 6th, 7th, 8th, and 9th. And first day is 30th. 30th also you can see all the hearing matters are there. So it may not be this week, though it's not possible. I think. Sorry, Monday is which date? 5th is not possible. 5th is not possible. 5th, 6th are not possible. 7 at best can be. 7 is 7th. Yes.
May I please, Your Lordship? I beg to mention item number 12, Lordship. 12 and 17 on behalf of Mr. S. Mudi, Lordship. Kindly let the matter be taken up after a week, Lordship. Item number 12, LCR has been received.
12 and
17.
12 and 17.
No.
Both the matters, Mr. Munir was appearing.
No, I'm making the mention.
Okay. Otherwise, scan copy of the case record has already been received. At the request made by so appearing appearing on behalf of Mr. S. Munir. After 1 week we'll do, or you want any fixed date? After 1 week?
After 1 week of fixed date, Lordship.
1 week we don't have any fixed date. Then it will be a later part. Either maybe 14th, 15th, 16th.
Can it be on 14th then?
14th.
14th. Both the matters.
Both the matters?
Both the matters. DP of late.
14th.
May I please, Your Lordship?
Yes.
Item number 43, today's list.
43.
43. LCR is not received as per office note dated 29/4/2025. Kindly pass over the matter on.
Are you on interim there?
No,
You are not on interim.
POXO matter here. Can it be on 14th?
POXO matter, but whether service is completed?
And it's completed.
Service is
It's
completed.
completed. Opposite parties, maybe a name.
Name is also appearing.
Yes, someone is. I already taken.
Okay.
Consent.
With consent of this as well. Otherwise also CD not received, no?
Yeah.
Scan copy.
Scan copy of LCR. Scan copy of the LCR along with the CD not received. Issue reminder, registry will do the needful. List accordingly, yes. 16/5.
Obliged. May I please, Your Lordship? Your Lordship, I beg to mention for listing of an AB, Your Lordship, for withdrawal tomorrow. Please.
May I please, Your Lordship? I beg to mention for listing one regular bail application, Lordship. For 2nd of April.
Second is not possible. That's what I'm saying. Second, third, almost 5. 5th and 6th are also same thing. Option give it a fine bit. Will be on 14th only. It will be on 14th only. Because fixed matters in every day these days, fixed matters, we have fixed day matters. You won't remember this things 30 to 35 fixed matters are there in every day, 5, 6, 7, 8, 9. So that is why it's maybe problematic for, so 14th may be there. 14th.
May it be please, Your Lordship. Lordship, I beg to mention item number 34, Lordship. Matter may be kindly possible for the day, Lordship.
34.
34, Lordship.
Yes, what is the position of 34? Scan copy has received.
Yes.
I did request made by so and so. List on 16, 17. List after 1 week.
Obliged.
May it please, Lordship? I beg to mention for listing of a bail application on 2nd of May, Lordship.
No, not at all possible.
Lordship 28th.
14th,
then
1/4.
5th.
1/4.
May I please, Your Lordship? I beg to mention item number 37.
In this
See.
matter, my lord, only last occasion the case diary was called from an. As on date, my lord, case diary has not been received. My lord.
CD not received. Are you on interim?
Yes, madam.
CD not received. Issue reminder. Interim be extended till next date of listing. Yes. When it can be 16/5 or 17/5.
90.
Because they are on interim. I
Yes,
think.
ma'am,
19/5.
May I please, your lordship? I beg to mention item number 3.
Item number 3.
Three.
Ah.
Matter kindly pass over for the time being. My senior is late in court number 24.
Okay.
May I please, your lordship? They are for listening in every lordship and can it be lordship on Friday lordship?
No, not at all possible.
Motion matter lordship.
Whatever, not possible. Motion in the motion column too, we have to hear all these matters.
As an urgency lordship.
19.
Published.
May it please your lordship, I beg to mention item number 42, lordship.
42.
Yes, due to some difficulty, my senior could not appear in this case, lordship. And
42, you are appealing for
for the applicant, lordship.
applicant.
Yes, lordship.
And CB is also there, no? One I is there for one in B.
Yes, lordship,
Probably.
for the modification of order, for the extension of order, lordship. We are on interim, lordship.
They are on interim, most probably on the medical ground. I have,
Yes,
yesterday I
lordship.
have perused the record, medical
Lordship.
ground, it was extended.
Lordship.
So on the last occasion also, due to some reason, again, it was extended. I don't know why.
Extend.
Yeah, we taken adjournment for filing of an affidavit, lordship, which we have filed already, lord.
And your objection you have filed or you are
No, no.
going to,
We are going to file lordship objection in the IA.
in the IA only?
IA lordship. They have filed it yesterday only.
Yes, lordship.
With the consent of the other side, the learned counsel appearing for the appellant, the applicant is able paid for an adjournment. Prayer allowed, means the matter accordingly. 2 weeks will do, after 2 weeks. Interim be continued till next date of listing. The NCB is respondent is hereby asked to file their written objection, if any, on or before the next date of listing.
Lordship. Much of.
DDD item 1.
Item 1 also you are appearing, Jay?
I am appealing for the DRI lordship.
GRI, yes. Who is 1? A Medhi. She is not here. None appears on call for the petitioner. Standing counsel DRI is present. List the matter accordingly after 2 weeks. It's a B, na? B, na?
BA.
1 week after 1. Okay.
Much of it.
Item 2.
Lordship,
Yes.
petitioner has been arrested on 21/2025, Your Lordship.
20.
20, Your Lordship. 1/2025.
125.
Allegation under 22B of NDPS Act, Your Lordship.
22B.
60 days.
over, but we have to take instruction whether certificate has been filed or not.
Lordship,
Otherwise,
petitioner is also seeking bail on the ground of arrest has not been mentioned in the
Pardon?
ground of arrest has not been mentioned.
No, that apart, yes, maybe there may be, and otherwise also it is 60 days is almost over.
Yes.
So you take instructions then,
At 2 p.m.
add to. Okay.
Okay.
Item 4.
Yes.
Lordship, I am praying for time being, Lordship. Senior will be appearing.
For time being. Okay.
Of like.
5.
May I please, Your Honor, it is a search-seated measure. Allegation is under section 4 of POCSO Act, Lordship.
notice and scan.
Notice has to go.
Oh, yes, Lordship.
You take steps within 2-3 days
Yes, Lordship.
to judicial police station, report to the office of the registry and the public prosecutor. In that way, you take steps. You have not made party, I think. Informant, you have not made party.
You have to change the perspective.
You
Yes,
have not made party.
yes, Lordship, I'm Change the post title. please.
You are MS,
A Begum.
A Begum. And also heard Mr. R.R. Kaushik to learn additional BP. It is submitted by MS Begum that due to some inadvertent mistake, the informant is not made party in this case. And accordingly, she submitted that one interlocutory application will be filed in that regard. List the matter accordingly. How many days do you want for the filing of this interlocutory?
3 days.
3 days, we don't have any date. এতিয়া কৈ দিওঁ চব কৈ দিব পৰা যায় নেকি 21/5 No, this is a bail application. She want to go interrogatory only for some reasons. 16th also. Maybe on 9th also, because he is in custody. 9 is very lots of matters are there. 9th. 1-3.
Publish.
They know how I said about that.
Item 6.
Your Lordship.
Yes.
Your Lordship, for 83 DNSS application, Your Lordship. Here, FIR is at case number 14, Your Lordship. There are 3 accused persons, Your Lordship. And one is, Your Lordship, all are the family members, Your Lordship. The accused number 1 is the son of the petitioner of this case, Your Lordship. And here, Your Lordship, item number 9, Your Lordship, the rest of the accused persons are there. Item number 9, Your Lordship.
Okay, we'll take together.
Lordship.
You are appearing in both the matters.
Both the matter, Your Lordship.
9-2 delivered. Okay. Yes, now
Yes, Your
tell us about 6.
Your Lordship.
Yes.
Yeah, Your Lordship, the FIR was registered under section 1152 of the BNS, Your Lordship, 1182, 109, under section 3, 5, 66A of the IT Act and 67 of the IT Act, Your Lordship. Here, Your Lordship, kindly come to page number 14C, Your Lordship, the vernacular portion of the FIR, Your Lordship. May I read the FIR, Your Lordship?
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই উজ্জ্বল দা পিতা প্ৰফুল্ল দা আপোনাৰ আৰক্ষী চকী অন্তৰ্গত ৰংমহল গাঁৱৰ স্থায়ী বাসিন্দা হওঁ মই আপোনাক জনাও যে আমাৰ বান্ধৱী এগৰাকী বৰ ৰংমহল নিবাসী বাগিচা সাগিছ আলীয়ে প্ৰেমৰ প্ৰস্তাৱ দিয়ে বান্ধৱীজনীয়ে সাগিছ আলীৰ প্ৰেমৰ প্ৰস্তাৱ প্ৰত্যাখ্যান কৰাৰ বাবে বিভিন্ন ধৰণৰ ফটো ভাইৰেল হোৱাটছআপ গ্ৰুপত লগতে ফোন সাইটত আপলোড কৰি দিয়ে আৰু তাক মানসিকভাৱে নিৰ্যাতন চলায় ইয়াৰ ফলত সমাজৰ আগত হেয় প্ৰতিপন্ন হৈছে আজি 9 এপ্ৰিল 25 তাৰিখে সন্ধিয়া প্ৰায় 8:18 মান বজাত এই কথাখিনি আমি সাগিছ আলীক তেখেতৰ গৃহৰ সন্মুখত দেখি ফুটফুচ কৰিবলৈ যাওঁতে তেখেতৰ পিতা সাগিছ আলী তেখেতৰ পত্নী সাগিছ আলীয়ে আমাক ইটা টাঙোন আৰু ৰড লৈ গুৰুতৰভাৱে মোৰ লগত বিকাশ দাস আৰু কল্যাণ দাসক প্ৰয়াস কৰি হত্যা কৰিবলৈ চেষ্টা কৰে এই পহাৰৰ সময়ত কল্যাণ দাসৰ মূৰ ফাটি তেজ ওলাই যায় ইয়াৰ লগতে কল্যাণ দাসৰ মোবাইল ফোন আৰু মোৰ পাৰ্স তেওঁলোকে বলপূৰ্বকভাৱে ৰাখি লয় This is the case, Your Lordship. Now, Your Lordship, if Your Lordship kindly come to the forwarding, Your Lordship. I'm reading the relevant portion, Your Lordship. At the second page, Your Lordship. 18, Your Lordship. 18. Here, before reading this forwarding, Your Lordship, some little submission on my part, Your Lordship, that Your Lordship, the cases that Your Lordship, the son of the petition, in this case, Your Lordship, is a holder of Rashtrapati Award, Your Lordship. Here, Your Lordship, the whole FIR is a malicious, Your Lordship. Here, what happened, Your Lordship, some of the friends, the complainant are the friends of the son of the petitioner, Your Lordship. They visited the residence of the accused person and falsely alleged that the son of the petitioner shared some phone number of the girlfriend of the complainant, Your Lordship, in some WhatsApp group. And in this way, the whole incident started, Your Lordship. And what happened? All the complainant, Your Lordship, all the friends, they are the friends of the son of the petitioner, in this case, Your Lordship, they assaulted everyone, Your Lordship. the family members of the lordship, the petitioner. Accordingly, your lordship, the wife of the petitioner, in this case, your lordship, approached Gauripur police station for complaining, your lordship. But my part of the FIR has not been registered, your lordship. To take safeguard, your lordship, from all this thing, your lordship, the accused persons, your lordship, the complainant, your lordship, filed this case, your lordship. I'm reading the FIR, it reveals the thing, your lordship. During the course of investigation, examined to the complainant of the case as well as victim and arranged him for medical examination and treatment and examined to the witnesses. Visited the PO and drawn up his sketch map and also examined two local witnesses. Seized a mobile phone from the possession of FIR name accused, namely Sahira Begum, in presence of Seizure witnesses, which was snatched by the accused person. On through interrogation and examination to the suspect accused, Sahira Begum has been released from outpost in an undertaking bone while she come to lodge a counter FIR on 10 April 2025 at evening. Moreover, since after committing the crime, both FIR name accused Saziz Ali and Satif Ali managed to flee away to evade from police arrest, and till now, accused Saziz Ali has been absconding and arrested. Accused Satif Ali has been apprehended while he come to his house on 10 April 2025. Lordship, this is the relevant portion, your lordship. What I trying to convince this honorable court is that, your lordship, that my part, I have also filed an FIR, your lordship, before the Gauripur police station, but that FIR has never been registered, your lordship. But the FIR of the complainant, your lordship, against me has been registered, your lordship. Here you directly or indirectly, your lordship, with the instruction, your lordship, from my client, your lordship, the police person also involved in this case, your lordship. What is the instruction from my client, your lordship? Now, your lordship, kindly see, at the time of arrest, your lordship, some notice has been served, your lordship, under section 47, your lordship, and 48 of the DNSS. That is at page number 20, your lordship, annex of 4, your lordship. Here, your lordship, the whole notice, that is 47 and 48, scripted in English, your lordship. The petitioner, your lordship, in this case is an illiterate person, your lordship. And in this regard, your lordship, I would like to rely on paragraph number 12, your lordship, to 14 of Bihan Kumar case, your lordship. I have highlighted the portion, your lordship. Lordship will know the fact of the case, so I'm not going to rely reading the above. I have highlighted the relevant portion, your lordship, from 12 to 14 regarding the, in regards to the language of the notice used in the notice, your lordship. One more judgment, your lordship, I'm relying, your lordship, that is Hari Kisan versus State of Maharashtra, your lordship. Here also is my head note, your lordship, relevant to my case, your lordship, the head note, your lordship. And here, your lordship, the article 22 and article 21 of the constitution has been violated in my case, your lordship. One more plea, your lordship, that I'm going to take in AB also, in item number 9 also, your lordship, because the petitioner belongs to a reputed family, your lordship. Because your lordship, in item number 9, your lordship, the petitioner number 1 is a 24 years old person, your lordship. He's a boy, your lordship. Here, your lordship, he is the holder of a Precedent award, your lordship. Pays, your lordship, (23), your lordship, annex 6, your lordship. In there also I have annexed, your lordship, in the bail application also, your lordship, item number 6, your lordship. Under National Service Scheme Award, your lordship, for the year of 2021 and 2021 to 22, your lordship, for his tremendous work towards the community, your lordship. Now, your lordship, for the year of 2025, he also applied for National Youth Award, your lordship, for this under the head of central government, your lordship. Now, for this, your lordship, one police verification is needed, your lordship. Probably it is going to be declared in the last month of 2025 to restrain the petitioner. In item number 9, your lordship, the whole conspiracy is going on, your lordship. So, lordship, he's the person, your lordship, who has applied for the award, your lordship, and his verification is going on, your lordship. So at this stage, your lordship, at basically at item number 6, your lordship, because 47 and 48 has been violated in terms of the language only, your lordship. Otherwise, that is okay. The other contents is okay, your lordship. And regarding the 48, your lordship, that is also not complied with, your lordship, with due respect, your lordship. Your lordship, at this stage, your lordship, your lordship deems fit, your lordship. One more aspect I forgot, your lordship. Here, the case has been registered under 109, your lordship. But if your lordship kindly see and under section 3, subsection 5 of the BNS, your lordship. Here, that is the common intention, your lordship. If that is so, your lordship, one of the accused person has been released by taking an undertaking, your lordship, by the police authority, your lordship. So it reveals itself, your lordship, how manufactured the case is, your lordship. That is my submission, your lordship. Otherwise, I leave to the this honorable court, your lordship, in both of the matter, your lordship.
Yes.
My lord, at this stage, I will reply for the call for the CD, my lord, because my lord, here lot of submission has been made, my lord, that this person is illiterate and all these things, my lord. So we need the CD to verify all those things, my lord.
Obviously, because illiteracy and illiteracy at this stage will be problematic for us also to decide, in fact, whether they can read or write on whether they are not in a position. Now, in case of AB, what do you want to say
In case of AB, my lord, specific allegation is there, my lord.
against him? He is Sadish.
Suggestion, my lord.
But your lordship, he is a person, your lordship, who represent, your lordship, who is the holder of Rashtrapati Award, your lordship. I have
That
annexed the
doesn't guarantee, my
photo,
lord.
your lordship,
His
that
conduct,
is,
my lord.
will appear
My lord,
before.
there are several cases.
See, obviously, he got the award for doing some good works for his
Lordship,
community.
Lordship,
That is understood.
lordship, lordship,
But on the other hand, ECB's character says that he is harassing a girl,
lo-
whatever.
lordship,
So
lordship.
how can you say that?
But lordship,
He may
has
be an award recipient of a Rashtrapati
lordship,
Award.
lordship.
Maybe there.
My lord, in
But-
fact, one of the Padma Shri awardees is now behind jail.
No,
Pardon?
because
One of the Padma Shri awardees is now behind jail in Assam only.
that is another aspect, your lordship, because he's a young boy, your lordship. Lordship, if your lordship, any incriminating materials, if your lordship found on the event of receiving the CD, your
That
lordship,
Sahira, she was released. But
she was
My lord,
released, your
that's why
lordship.
that also makes a case, my lord. Police investigated the matter initially. They didn't found anything against her. So release, my lord. If it is a make-out case, then they could have arrested her also.
No, that time, your lordship, already FI has been registered, your lordship. If your lordship kindly see the forwarding, your lordship will got to know, your lordship. Lordship, at page number 18, your lordship. If your lordship kindly see page number 17, your lordship, already case has been registered, your lordship. Under section 109, 67, 66, IT Act, your lordship, already registered, your lordship. So police has the case, your lordship, under that registered section, your lordship. So in item number 6, your lordship, leave this honorable court, because yes, the literacy and non-literacy subject to some verification, your lordship, that I can understand, your lordship, with due respect. But in regards to item number 9, your lordship, my humble prayer, your lordship. At
so the
this,
person who viral the photographs and all, he is this one.
AB.
AB. AB is the person.
He's the main person actually.
He is the main actually.
Lordship, as per allegation, he is the main, your lordship. As per allegation, your lordship. If your lordship kindly see my case, whether my FIR, your lordship, my FIR has been never been registered, your lordship.
Item number 6, is it? Item number 6, the call for the, we're trying to give a short data the divorce record. Date Nike Kuribo. We are in helpless condition. In fact, we don't have dates. All are insisting date for 9, 10, 11, 12. How can it be possible to accommodate all the advocates with these dates? That is our big problem here.
My lord.
If you fix a date for after 1 week or 2 weeks, no one will agree. Everyone is insisting for date. Then date on up to 15, 16, you can see flourishing with the dates and all. They're creating a very big problem for us, in fact, giving dates, in fact.
Lordship, item number 9, I can assure I will cooperate with the investigation agency, your lordship. Any condition, your lordship.
Six to have a city call for can be called for. Somehow. 6 to city call on 9/6. Sorry, 9/5. And in item number 9, we call heard heard MSG Bora, the learned counsel for the petition, and also heard Mr. R.R. Boshi, the learned additional PP, appearing on behalf of state respondent. Baki, this is an application with section so and so in connection with so and so. Next part, considering the submission made by learned counsel for both sides and also considering the materials in the case record. The petitioner number 2 is hereby granted with interim pre-arrest bail, granted with the privilege of interim pre-arrest bail till next date of listing. However, no interim pre-arrest bail is granted to the petitioner number 1 at this stage. Let the CDB call for on 9/5/2025. The condition detail. Petitioner number 2, we are granting with bail on petition number 1.
Much obliged.
Okay. Petitioner number 2, Divo. 1 is we are not granting and fix it for 9/5.
7.
This is a lordship. Lordship, 483 application. At this stage, my humble request will not call for the case records along with the diary, madam.
It is a charge sheeted one?
Yes, madam, charge sheet, madam, and at the mark to my instruction, it is at evidence stage, madam.
Acha. As per you.
Yes, ma'am.
Okay. Scan copy of the case record along with the CDB call for. Registry will do the needful. 16, 17 on the other to the
16 is possible. 16 if possible, madam.
Okay, 16.
Deeply obliged, madam.
Item 8.
Please also, madam.
Yes.
Here is the application, madam. The my lord offense is my lord criminal misconduct, my lord. Illegally enriching, my lord. Petitioner is a Mondal, my lord, in Bipura Revenue Circle, my lord. So he has a house, my lord, a 3-story building, my lord.
Do said Mondal.
Mondal, my lord. His wife is an advocate. He also, prior to joining in service in 2004, he was worked as a contractor, my lord, in Arunachal Pradesh, my lord. Yes, my lord, some money, my lord, and service, wife contribution and parents contribution, he constructed a building, my lord. But anyway, there is a, my lord, allegation of enriching illegally, my lord. The complaint was not exact complaint, the information of received by the police lordship come to page 18 FIR, my lord, in 2021, my lord. Now FIR has been registered on 2024. Lordship, may I read, my lord, FIR? Page 18, my lord. With due reference to the subject cited above, I have the honor to inform you that Gov. PE Nong 4/2002 was initiated based on a confidential report submitted by the Superintendent of Police Lakhimpur, not Lakhimpur, Assam, by Lieutenant Soso 8/11/2021, which was submitted based on a confidential inquiry conducted by the local police of Lakhimpur district, alleging that the Kusheshwar Dr. Da Did and Latmondal, Office of the Circle Officer, Bipuria Revenue Circle, Lakhimpur, Assam, while rendering his service at the Office of the Bipuria Revenue Circle, Assam, accumulated asset disproportionate to his known source of income. He was also involved in illegal land-related activities. The PE was endorsed to a undersigned inquiry fight order dated so and so. In course of inquiry of the above noted PE, it has been learned that there is a 3-storied building, big size, 300 square feet approximately in first floor, surrounded by the concrete boundary wall with iron gate in the entrance, road facing side, found in the name of the suspected officer, Sri Kusheshwar Dutta, so and so, Harmoti under the Laluk Police Station, District Lakhimpur, Assam. During the inquiry, it has also been come to light that this SO Sri Kusheshwar Dr. Latmandal Bipura Revenue Circle, Lakhimpur, Assam has a big size of residential compound with a modern house facilitated with multiple parking space surrounded by Paka boundary wall, which is located in Tubia Bosti nearby Harmoti under the Laluk Police Station, Lakhimpur District. It was also confidentially learned during the inquiry that the SO Sri Kusheshwar Dr. Latmandal Bipura Revenue Circle, Lakhimpur, Assam had acquired more land and landed property, commercial building and Lakhimpur district as well as in Guwahati. These are, my lord, I am denying this allegation, but I have a 1-story building. So I have joined in the 2004, my lord. It has been, my lord, initiated in 2014, my lord, just foundation, my lord. 16, there is a 2 Sat Dhalai, my lord. Thereafter, my lord, in 18, I have completed ground floor and first floor, consisting 7 my lord, residential part, my lord, small residential part, 1 bedroom, 1 kitchen. My lord, then rest of the third has been constructed, my lord, due to income generated from the other 2 floor, my lord. This is amounting, my lord, mostly 30 lakhs, my lord. And I have taken loan from 10 lakhs. My wife also some contribution. I have my contribution from my service, but there cannot be, my lord, illegally enriching, my lord. And this is a documentary evidence. My apprehension is that, my lord, the last page, my lord, this annexure 5 to page 22, my lord, the superintendent of police, my lord, director of vigilance, my lord, anti-corruption, wrote a letter to the, my lord, district commissioner, my lord, to provide those documents relating to me, my lord. Recently, my lord, 17 March. And the information, my lord, is been 2022, my lord, 2021, but the government office reached, my lord, 2022. Now 2024, they have registered. Now in, my lord, 2025, 17 March, this has been communicated. My apprehension is that, my lord, I may be arrested, but all are documentary evidence, my lord. If this document is required, I have no access all those documents. This is the government documents, my lord. Regarding my land, house construction, they may can from a town committee also, they can collect, my lord, the value of the house. Otherwise, my lord, I will cooperate with the investigation. In the meantime, I am protected, my lord. The city may be called for, my lord.
Yes.
Well, here kindly peruse the FIR, my lord, because this FIR has been, kindly note that, my lord, this FIR has been based on a inquiry, previous inquiry. It's not that they have directly filed the FIR, my lord. It has been conducted, and during the inquiry, it has been found that he has disproportionate property, my lord. So, my lord, considering this aspect, my lord, at this stage, my lord, I call for.
Yeah, obviously, if you go, I have also perused as Mr. Sarania has read out. The FIR is obviously after inquiry, in fact.
My lord.
So after inquiry, it was found that not only the building, but the other properties as well. The
Right.
commercial complex also, these are there. So obviously, if you go by the one that bundle, how can he create such disproportionate property? So there may be, as Mr. Cerny has submitted, there are other sources of income also. His wife is also an advocate. There may be one of the reason, but the question is that apparently, if you see that obviously there is a case. So we also think that CD is required. CD is CDP.
My lord, till the interest protection, because all are documented. If it is on inquiry, my
It
lord.
is already documents, definitely, if it will come with the CD.
My lord.
Suppose the documents have already been collected as you have submitted,
My lord.
obviously these are the based on documentary evidence, to some
My
extent. Or otherwise your interrogation may be required, but in that case, you may be
I'll
granted with
cooperate,
interim
my lord.
also. But the question is that at this stage, I don't think it is a case of interim at present.
But because of that, my lord, there is no scope of, my lord, doing anything within the inquiry, because I'm not going to, my lord, influence anybody, my lord, because all document has been seized, my lord. My apprehension is that this document is sought for, my lord. After getting this, I may be arrested, my lord, without notice, because it is more up to 10 years, my lord, punishment. Not less than 4 years, up to 10 years, my lord.
These documents,
So no notice is not required, my lord, if 10 years, my lord.
these documents are sought for from the DC office, not from him.
That my apprehension
That-
creates, my lord, because of
As
this.
per this letter, this has been
Yes,
sought from the
obviously.
DC office, not from him. My lord.
Because
And
they are
if
going
he
to
is
collect
doing
from
it,
these
it-
documents
it's
from the
my lord.
district,
District
not from
office,
you.
my lord.
DC office.
So we are
Yes.
calling for the case diary. Let us see what happens.
Yes.
My lord,
If
take
already all the
protection, my lord,
documents
because
have been
I'm
collected,
the
then
job, my
maybe a
lord.
case for anticipatory also, maybe. maybe.
While I'm in the job, because if he's arrested, detained for more than 48 hours, I'll be lose my job.
What
my
to
lord.
do? We have cases in that manner, only corruption
My lord,
cases there.
because of this, all are
Okay, then
documentary
we are
evidence.
calling for
My
the
lord.
case diary when it can be called for, yes.
Any day.
My lord, maybe that, my lord, if lordship not considering, my lord, maybe within 1 week, my lord.
1 week, we are flooded with case record, in fact.
Then till then, next week, my lord, I'll be
16/5,
protected, my lord.
16/5.
I will be protected till then, my lord.
Sorry.
Because,
6/5.
my lord, my apprehension is bona fide, my lord. My apprehension is bona fide.
On 16/5.
Item 10.
Or 9. Don't remember what I call like. I plus is a commercial property. This is another lot one of it. So anyway, it's it to do my January. It also be
Because.
yes, yes. This is your
Charge sheet.
this case is fixed in this court, and do you have any other cases today?
No,
No. No, I thought the 2-3 other cases are also there.
no. Other cases also there.
No, not in my court. in
No,
other
not,
courts.
not
Ah,
before lordship.
okay.
But it is
You have come from
oh,
there. no,
yes.
That's why
Only charge sheet has already been filed, my lord.
here.
My
Chassis has
problem
already
is,
been
my
filed.
lord, after the filing of charge sheet, we
Hmm.
file an application for anticipatory bail because I am showing as a absconder. So
Hmm.
I am filing an application that the additional district judge, Dibrugarh, my lord, on merit, the bail application was rejected. So it is a session tribal case, is a petroleum products, steering of the petroleum product. So the matter is pending before the committal court. So therefore, if I'm appear, my lord, then naturally, lordship also, my apprehension is to, not to get any.
So what is your plea? Why
So,
you have not
my-
appeared before the IO during investigation?
No, lordship, no notice has been issued to me. That part is there. I am showing it the absconder that there, my lord. Against me, as per the FIR allegation against me is the driver of the truck, this is oil tanker. He disclosed my name that I am there. Otherwise, this is a co-accused statement. On the basis of that, I was there. And also, there is some bank transaction with the main accused in the bank. That's the allegation is there. I will face the trial, madam. My only
No, we are not on merit of the case.
No,
We are
yes,
just
I
asking
will
why
appear.
you are not cooperating in the investigation.
No,
That's all.
my only point, so far instruction is concerned, my lord, that no notice has been issued to this petitioner. He filed the bail application before charge sheet also. That was rejected. Then after charge sheet, because on 30th January the case was registered, and in the March in the month of April, 11 April charge sheet was filed. A very short period. So my only prayer, my lord,
Informant.
I would appear, my lord,
FIR was registered
on 13th January.
Okay.
On
And
31st January to 25. CS is on 11/4. It's good effort by the police, my lord. For a very short period, the charge sheet was filed. Appreciated efforts of the IO, my lord. But I only pray, my lord, that a outer limit bail may be granted, my lord, because warrant has been naturally limit I am showing as absconder. And
No,
I will
no,
appear, my lord.
Even
And
if you are showing as an absconder, warrant may not be there, but is there any warrant?
no,
Do you
lord.
have annexed any?
No, lord. Nothing.
No, have you annexed the order sheets also? No.
Yes, I order sheet I have annexed. Trial court I am not annexed, my lord. But nowadays, my lord, the notice has someone is issued. Nowadays,
No. After charge sheet, have you annexed the order sheets here?
No, my lord. After charge sheet I am not. But it is
Kenaga janin please tell them. How
someone
can
has
you
been
know
issued,
whether
my lord.
against you someone
I made
issued,
a
warrant is
statement.
issued?
No, I made a statement. Someone has been issued. I made a statement. Someone has been issued. And today is the date fixed, my lord. As informed, my lord, today is the date fixed. I will appear within 15 days, my lord. Till that, I may be protected.
And it's here because he cannot circumvent that process, my lord. He was not available during whole investigation, and whether notice was issued or not, We cannot say.
We are
without
not
going to
in a
that
stage
extent.
to say.
And my lord, kindly peruse the order of the court below.
Hmm.
That plea was not taken before the court below, my lord.
Acha.
That plea was not taken. And he has not received the notice. They are silent in the court below, in the order, my lord. From the order, whatever I have understood.
There is no allegation, my lord, in the charge sheet also. Yeah, I am not cooperating or the notice has been issued. The entire charge sheet we have filed, my lord.
So my prayers to call for the report, my lord. Otherwise, this offense is in a serious nature, my lord. Offense is in a serious nature, my lord.
That's fine, my lord. Before trial, I may not be convicted, my lord. And perhaps, my lord, I have a case, very good case. On the statement of a co-accused, I implicated. So it is very difficult on the part of the prosecution. There is no direct, nothing recovered from me. So it's very difficult on the part of the prosecution to prove. And let this matter be trial. I have nothing to say, madam. I will, because unless I am appeared, the committal court cannot proceed further. That's the problem. So let the matter be expedited as the IO has filed in a very short period, the charge sheet has been filed. So let the matter be expedited, nothing will lose, my lord. Within 15 days, I will appear. And my appearance will expedite the trial. It is difficult on the part of the committed court to commit the case without my appearance. That's my only limited prayer.
Next. Part Mr. B. Datta, the learned senior advocate, assisted by Mr. Sharendra as Deca, counsel for the petition, and also heard Mr. R. Kaushik, the learned additional PP, appearing on behalf of state respondent. And this is an application, the section so and so in connection with so and so. It is submitted by Mr. Dr. the learned senior advocate that the present accused petitioner is no way connected in the alleged offense, and it is the recovery was made from a truck, and on the basis of the statement of the co-accused, his name has been shown in the charge sheet as an absconder. He was never searched by police during the investigation, nor he was served with any notice, to appear before the IO and to cooperate in the investigation. However, the accused petitioner is ready and willing to appear before the learned trial court below on each and every date and to contest the case if he is provided with some interpretation. He further submitted that summons has already been issued against the present petitioner, and coming to know about the issuance of summons, he appeared before this court with the present bail application. Mr. Doctor further submitted that his earlier bail application for anticipatory bail was rejected by the court and which was entirely disposed of on merit. Next, Mr. Kaushik, the learned additional PP submitted in this regard that case is of serious in nature and the petitioner did not take the plea before the learned trial court below regarding the non-receipt of any notice from the investigating officer during the investigation. Mr. Kaushik accordingly submitted that his record may be called for to know the status and resolutive facts of the case. Next paragraph. Considering the entire submission made by learning counsel for process, perusing the case record, I find it proper to no.
In para 11, I have stated, my lord, that summons has been issued.
That summon has been issued. No?
Yes, by the magistrate committed.
Considering this submission made by learned counsel for both sides. And on perusal of the case record, I find it, I hereby direct the petitioner to appear before the learned trial court below within 15 days from the date of order. And will file a regular bail application which may be considered in accordance with law. However, till 15 days or from the date of order, the present petitioner will be interim protection is provided to the present petitioner, and no coercive action shall be taken against the present petitioner till date. Okay, we'll be
Yeah,
provided
grateful,
with
my lord, grateful.
disposed.
Application may disposed of.
Disposed of. Who is coming? Oh, now, Mr. For which one? Oh. Yes, yes, yes. I think that, you know. It took a whole year second. Oh, court room.
Oh, my lord, I was in other court, my lord. But here is a
No, we
case.
will accommodate you anyway.
My lord. But in this case, 71 days already in custody.
How many?
71 days.
Okay.
POCSO is there.
Oh,
And other allegation, my lord, that 47, 48 also your lordship kindly have a look, my lord. Now,
POCSO is there, notice.
that is there, my lord.
oh,
What
is
is to
there
be done?
that we don't have any alternative.
Yeah,
Is 71 days.
71 days in custody.
From where
And
the
she
notice has
almost
to
she
issue.
17
To
years.
Biswanath Chariali.
And the guard is only 17 was 1 month as per FIR, as per FIR. Everything was agreed upon, my lord, and our case was that you complete 11 months, you become major, then you will make it. That was but ultimately, my lord.
Maybe this may be
But
case
anyway,
for
my
bail,
lord,
but
this is
yes,
that case, my lord.
Well, let
we have
him
formed
through police station. We'll take instruction.
today only you take the step today or day by tomorrow.
Today, my lord, will take one day.
Instruction.
Opposite instruction, opposite body POCSO to.
No, মানে আমি আপনি স্টেট করলে condition instruction পাবো না আমি থানাতে পাঠিয়ে দেব
You will take immediately in instruction because 71 days is
Yes,
already
already.
there.
Could take 2 days, so my lord.
2 days.
2 days, so only next week, my lord, your lordship may fix, my lord.
Oh. Hard Mr. H.I. Chaudhary, the learned senior advocate, assisted by Mr. S.S. Ahmed, and also for the petition, also heard Mr. Arnab Kaushik, the learned additional PP, appearing on behalf of said respondent.
Can you tell me
This is an application simply issue notice to the respond number 2 through judicial police station, routed to the office of the Ministry of the Public Prosecutor. Mr. Kaushik, the learned additional PP, is also hereby asked to take instructions regarding the service of notice on the respond number 2. Okay, we are listing it on either maybe 6th, I think, or he is in custody.
Yes.
6th, okay?
Oh, but.
We are listing it on 6th.
And
And he will take instructions
yes,
also.
within
And on the day itself, we may appoint an amicus also.
Obliged.
Timing 3.
Have been in custody since 27/10/2023. And this arrest count I have taken, my lord. These are original certified copies. May I permit to place, my lord.
And what is the status of the case?
Status, my lord, even charges, evidence is not taken, my lord. Yet.
Not yet.
Not, it is still in appearance stage, my lord.
Why?
Although 1 year, 6 months have been elapsed.
No, why in appearance still?
It is, my lord, the reason is not there, but order I have annexed, my lord.
No, whether one is absconding or
No one is absconding.
why it is in appearance stage, that's what I'm asking. If charge sheet is already there,
Yes, ma'am.
why?
Because in charge sheet, my lord, in charge sheet, the total accused persons, five are in arraigned as an accused, my lord.
Where's the order sheet? You have five.
Charge sheet, my lord, last.
Last order as per the next document in 9/4/24.
9/4/24.
24. So I request for calling for a scan copy.
We don't know the position.
We don't know the current position.
My lord, my humble submission, these are arrest ground I have taken, my lord.
Pardon?
This arrest procedure ground I have taken.
You have taken.
Yes, my lord. These are
Now,
original
is
certificate.
your from your conscious position or?
Not my conscious possession, my lord. This I have taken, my plea, my lord. It is recovered from a pawn shop. I am not the owner of the pawn shop. My house is situated nearby the pawn shop, my lord. So after performing my Zumma prayer, I have visited the pawn shop to take a tea. And suddenly police came and something recovered from pawn shop. So I was taken by the police on suspicion. These I have
The pawn shop belongs to you.
not belongs to me. I am Hassan Ali. My house is situated nearby the pawn shop. This little area, my lord. After performing the Zumma prayer, it is on Friday, my lord. The Zumma namaz is there. So after performing Zumma namaz, I have visited a pawn shop. There is a tea shop is also there for taking a tea. Accordingly, tea was taking. Suddenly, police came and something recovered from the pawn shop. So I was taken by the police on suspicion. I'm not the owner of the pawn shop, nor the owner of the materials. It is on there in the FIR, man.
From the FIR revealed.
Yes, my lord. It is FIR. It is there.
As far as Seizure list, it is recovered from Hassan Ali from this 5% member.
It is just
But
name has
Seizure-
been erased. It is there whether it is from recovered from pawn shop or not. This is in there.
So that my lord, we
No, no,
scan
you are
copy.
Hassan Ali and recovery is there.
Yes, madam. Along with 4 other person. As per the Seizure list, madam, whatever document is.
My lord, a pawn shop is a small pawn shop. How 5% has been erased from the how the recovery made from a 5% from a small pawn shop.
My lord, that has cannot
This
be
is
decided
a
now. my-
clear case of my suspicion, my lord.
No, that cannot be decided now.
Police just erased, my lord. So whether the exact recovery, it is the matter of trial, I'm saying. This is not the trial of bail, my lord. My humble submission, 1 year, 6 months have been elapsed. An arrest procedure ground, I'm saying. And also, my lord, on
No,
prolonged
that's what
incarceration.
we are saying, that's why I'm just asking you whether recovery was from you.
Not recovered
Or,
from me.
but the Seizure says otherwise.
Caesar says just, my lord, that there have arrayed 5 persons and saying that we have recovered from this 5%. How 5%, my lord, recovery made from a 5 persons where it is recovered from a pawn shop?
That we cannot say it.
I think
My lord,
that's why we
kindly
need a
see,
scan copy, my lord.
kindly see
Without
the,
record, we cannot say right now.
my lord, kindly see, I have taken the para 4, page 5, page 5, para 4, may I read, my lord. That the petitioner,
Para 4.
page 4, para 5.
Hmm.
That the petitioner begs to state that the way of investigation of the police is underground, as in the FIR format, the GD number mentioned is 796. However, in the body of the FIR, GD is mentioned as 784. In the seizure list, the column of the date and date of the seizure, the time is not mentioned. That is the time of the seizure in the seizure list. In the backpack, which contains 22 numbers of multiple of soap cases, inside which contains heroin. The weighing process of the gross weight of 22 numbers of soap cases was weighed. The weight of soap cases is not segregated from the suspected heroin. However, the gross weight of suspected heroin was found 277.22 grams. It can be assumed that the weight was mixed up with the soap cases and suspected heroin. However, in the seizure list, in weight portion, police simply written without soap cases within a bracket. Thus, the quantity shown in the seizure list cannot be accepted. That the petitioner begs to state the bag containing the suspected contraband was recovered from a pawn shop. The pawn shop is owned and being run by Babul Hussain. The bag which was seized from the pawn shop was belonging to Tunhaluyan Langel. The police mentioned in the seizure list that the bag is absolutely belonging to Tanlihan Langel. The petitioner had not possessing the bag. The bag is not belonging to him. Under such circumstances, it can be conveniently concluded the petitioner is not in possession of the seized contraband. Number 7, my lord. That the petitioner begs to state that as per the FIR, the information was received by
Where
police.
from you are saying this is a list back is absolutely belong to Hangling.
Yes, my lord. This is.
Is there any?
Yes, my
No?
lord. It is
Where
one
it
of the
is?
police Caesar list. It is Caesar list, my lord. That Caesar list I have mentioned, my lord. Page 18 and 19 is and 20 is the type copy.
One Redmi mobile handset belonging to one someone.
Lanlihan Longal.
Yeah.
Circumstance after apprehension of the person from the PO, we brought up into Bodorpur during the lockup. Before intel, we have checked the body and found the same. This is another matter, page 19. Place of seizure from a pawn shop belonging to Babul Hussain Loshkar. Page 19 is the matter. Place of seizure.
From whom seized below?
From whom seizure? From the joint possession of Hassan Ali, Mubassir Ali, Babul Hussain Loshkar, Nazir Hussain, Tonlian Langel, Lal Sangh.
He is the Hassan.
My lord, how a bag shop, which was in pawn shop, is possessed by a 5 to 6 person. Is it believable, my lord? Just all persons' names have been erased. Those are found nearby the pawn shop. It is clearly said that it is recovered from a pawn shop. Bag is Tonlihan Longel. How my lord 5%?
No, we are not saying bag is talking. Only mobile handset
This
is.
mobile is saying, but
Bag is not told. Huh?
pawn shop is belonging to Babul Hussain
Oh,
Loshkar.
that is there. That
Yes,
is there.
ma'am.
That is there.
And it is recovered from a pawn shop. And
No,
a small,
bag, you are saying repeatedly the bag belongs to Tang Lang Hill. But it's not there.
Another I have found, my lord.
You have found somewhere.
My lord, circumstances Caesar, my lord.
Sorry.
My lord,
Page 20 is there, my lord.
here, if my understanding is serving on merit, so we need the scan copy. Without those, my lord, we don't know the what is
So,
the stage.
prima facie, there is no possession
My lord,
from
we
my
are-
part.
Then 37 will come, my lord.
Prima facie, there is no possession, my lord. The death possession cannot be believed. Bag is recovered from a pawn shop. So at best, my lord, the owner of the pawn shop can be implicated. How I can be implicated in this case?
So for that, without going to the report, we cannot say anything at this stage.
My humble submission, my lord. Your lordship, my lord, I am not playing any other district or any other way. The poor person who lies in Sribhumi district. Bail may be granted. I will appear in every date, man. In the trial. Every date, my lord. 1 year, 6 months have been elapsed, my lord.
And the
You have not
order,
annexed the order status
Yes,
of the
that is
case
order
also.
status is not
Status
there.
of the case is also not there. One last order is 9/4/2024. From where, how can we say that case is not yet even, I mean, the evidence is not established.
Evidence is not given. It is in the e-court. I have.
Okay, no, okay.
Evidence is not taken, my lord.
But whether it is in appearance is also no.
Not evidence. This is from the e-court. We can collect, my lord. We have checked it. Evidence is not taken.
And you have filed your certificate copy?
Yes, madam. These are original certified copies, madam.
Now, as you have submitted, I thought that he was not there, but the position recovery was as per Seizure list, not
As per Seizure
otherwise.
list, but my lord, I have.
From you also.
Yes, madam. I have placed my submission, my lord.
No, you are going to submit this one or what?
Yeah, these are original certified copies.
Oh, here you have
Yeah,
submitted.
here it is the direct one. These are original one.
my lord, as per search sheet also, it was recovered from him with 5%, my lord. Basically, they are drug dealers, my lord. So, my lord, if your lawsuit is going by the merit, my lord, I request for the scan copy. Because without that, we cannot say anything. Because the 37 mandate is there, my lord.
Yes.
It is his submission that he is not involved in all these things.
It is in the Seizure list, my lord.
My lord, that Seizure list and his name is there, my lord.
It is in the Seizure list where it is recovered from a pawn shop. This is an admitted fact.
No, pawn shop, but
Pawn
from
shop is
your
there,
position,
your position,
that is
joint
there.
position.
Pawn shop is owned by Babul Hussain Loshkar. It is also there in the Seizure
That is a
list.
matter of trial, my lord.
How can a pawn shop, my lord, from my possession, it can be presumed?
Yes,
my lord.
obviously, otherwise, I'm just thinking also, well, pawn shop, 5% cannot be there, but you were, as per the charge sheet, you were the drug peddlers, in fact. So all 5 were involved in the drug peddling. Though the pawn shop owner is one Babul Hussain and it was recovered undoubtedly from a pawn shop. That is, let us call for the case record and keep it. Otherwise, you are also taking
My
the
lord,
ground
my
of
humble submission, my lord, if your lordship required, my lord, I will submit all the latest order sheet before your lordship. On my lord, on Monday or Tuesday, my lord. Matter may
Not
take
only
some
order
time.
sheet, because my learned friend is taking the, is arguing on merit matter. From order sheet, I cannot argue regarding merit matter. And this 1 year, 6 months is not a criteria set by Supreme Court. Matter. There may be judgment, but those are not the criteria. That is not a ratio, matter. That has to be looked into in each and every case, my lord.
yeah, obviously.
Yes, my
In respect of merit, my lord, if we go to the merit, my lord, the possession cannot be implicated to me, my lord. It is recovered by pawn shop owned by some other person, my name has been erased.
Can it this
That
court
can
at
be
this
said-
stage held that, my lord, this issue while deciding a bail petition, my lord? It will be a
Because
mini trial, my lord.
Suppose in prima facie from the documents you have annexed, that is the charge sheet or the charge sheet and the Seizure list. It obviously says that recovery was from you. And your submission, I can understand that from pawn shop it was recovered and it was owned by one Ababul Hassan.
It
But
is in the Seizure list charge sheet also, my lord, it is recovered from a pawn shop.
yeah, obviously that is understood.
Yes.
That is, we are not disputing on that, but recovery was from you also. I mean, joint recovery, that was there. Okay, yes, when it can be called for.
My lord, registry will come.
No, raised it, but we have to give a date.
Any date, Your Lordship, please.
Pardon?
Any date, my lord.
Any date, we are in a position to say. কি করিব মানে এনেকুৱা অৱস্থা হৈছে এতিয়া মানে 14 or 16 will do.
On 9th, my lord. Otherwise, my lord, we have been in custody and prima facie, my
9th.
lord, it is a good case, my lord, prima facie. 9th, my lord.
কিমান of a case দিয়াৰ পিছত it won't reach. Okay, right.
My lord.
Case record along with the scan copy of the case record along with the case diary be called for. এইটো তেখেতক খুলাই দিবচোন. I have already checked your
Right.
case. Oh, that is good. So she is there here.
For hearing item 11.
We have already received the
Objection.
yes objection.
Not
Yes,
the
yes.
hard copy, but the soft copy, yes.
No, whatever you have received.
Yes,
Yes. And you have filed anything? Any
I
objection
have
or
written
argument?
argument.
Okay.
May I submit before your lordship?
Sure, sure. Back to একদম সাইডৰ ফালে argument আছে written argument. Side of the subside. দুইটা সাইডে চাব এটা সাইডে আছে. Yes.
May I, lordship? Lordship, on the last occasion, learned PP sir raised the objection emphasizing the issue of red-handed, to caught red-handed. On that footing, lordship, learned PP sir has submitted a judgment of the English judgment of the House of Lords. Now, the question here arises is whether our constitution holds the same position with that of the Constitution of England at that relevant point of time. The same question was the learned PP sir has raised the objection before Justice Kaushik Goswami sir, and the same question was raised there if our constitution holds the same position as that of England at that prevalent time. And to that, the conclusion what arrived is there is no such discussion on that our constitution and England constitution falls on the same footing. Likewise, lordship, our constitution in Madhulimaya judgment as submitted by learned PP sir, there it has been discussed that our constitution is on the similar footing with regard to Article 22 and 21 is on the similar footing with that of England, with that of Sixth Amendment of the USA and Article 34 of the Japanese Constitution. But it has nowhere discussed that England Constitution and our Constitution holds the same footing. And to that, Lordship, Honorable Justice Kaushik Goswami came to a conclusion, and for as many as yesterday, as many as 4 cases in the same grounds of arrest, bail were granted by the coordinate bench, Lordship. I have the BA number, I will provide it. Thereafter, Lordship, the England Constitution. The England Constitution treats these rights under an act called PACE, Police and Criminal Evidence Act, which does not consider them as fundamental rights, whereas our constitution treats these rights, Article 22 and 21, as the fundamental and inherent rights of an individual. Now, I will submit my submission with the judgment, Lordship. All these are, I have the judgment of the Honorable Supreme Court, Lordship. Thereafter, Lordship, in the judgment of Madhulimaya, it has discussed, Lord Simon has stated that in a case of red-handed, the accused may be aware of the grounds, and as such, in a case of high patent heaven, it may not be, it is not necessary to convey. To that, Lordship, I have read the citation thrice, and what my little understanding says is that, assuming a situation where in an open field, there is open fire going on, there is killing of people. In such circumstances, Lordship, the police officer will definitely not go on, put emphasis on preparing the grounds of arrest and handing over to the people. Obviously, the arrest procedure will follow first. So in our case, Lordship, in NDPS cases especially, there is prior information to the police officials. And based on the prior information, the police officials went to the place of occurrence with equipments, with all their gadgets. In such circumstances, Lordship, it becomes incumbent on the police authority, arresting authority, to convey the grounds of arrest. I will support it with the citation, Lordship. And Lordship, the written objection that I have submitted, in the first citation, Joginder Kumar, Lordship, in para 21, page number 11, it has discussed that para 11, 21, that there is a right to have someone informed, the right of the arrested person upon request to have someone informed and to consult privately with a lawyer as recognized by section 56(1) of the Police and Criminal Evidence Act 1984 in England. This is the version of the England Act. Thereafter, Lordship, in the same judgment, in the same para, in the later part, it has been discussed that these rights these rights are inherent in Article 21 and 22 of the Constitution and required to be recognized and scrupulously protected. For effective enforcement of these fundamental rights, we issue the following requirements. These are the requirements stated here. Thereafter, Lordship, in a Madhulimaya case also, Madhulimaya case submitted by learned PP sir, their bail was granted, Lordship. Assuming that the accused was caught red-handed, even then bail was granted, because holding that our constitution provides the fundamental rights under Article 21 and 22, and those are inherent. Thereafter, Lordship, I have submitted this judgment of Jasila Salchi. This is a 3-bench judgment. In this judgment, Lordship, in this judgment, it is a judgment of preventive detention. And in this judgment, the appellant was detained. The background of the case I am stating. In this judgment, the appellant was detained without.
You submitted this judgment in which page number?
In page number 22, Lordship.
22.
3-bench strength.
Yes.
The appellant has been detained without informing the grounds of detention, and based on which, and that is a violation of Article 22, subsection 5, and based on which the same was the appellant appeared before the Honorable Supreme Court. Now, what Honorable Supreme Court has held in that judgment also, the learned Solicitor General, they raised the objection that in a case where a preventive detention has been issued against an appellant, he most probably is aware of the situation why he has been detained, because he is a person who is of national, who may be a threat to national security or public safety. And in such circumstances, the detainee is already aware of the grounds of detention. In such circumstances, it is not necessary to inform him the grounds of arrest. Whereas the Honorable Supreme Court has held in page number 39, Lordship, para 20, para 23, last part.
Para 23.
23, the last part. I have
No.
highlighted the same last.
Yes.
Para 20, it reads as, it is immaterial whether the detainee already knew about their contents or not. In Marunisa versus State of Maharashtra, it was held that the fact that the detainee was aware of the content of the document not furnished was immaterial, and non-furnishing of the copy of the seizure list was held to be fatal. To appreciate this point, one has to bear in mind that the detainee is in jail and has no access to his own documents. Here it is held that even if the detainee was aware of the grounds of detention, even then submitting of the grounds of arrest is incumbent on the part of the arresting authority. Thereafter, in para 25, Lordship, page number 40. These court further went, may I, Lordship?
Yes.
These court further went on to hold that it is immaterial whether the detainee already knew about their contents or not. These court reiterated the position that it being a constitutional imperative for the detaining authority to give the documents relied on and referred to in the order of the detention pari passu the grounds of detention, it has been held that there is no question of demanding the documents. Thereafter, the observation, coming to the observation of this in page 63, para 72. Para 72, it has stated that reiterated that what has been laid down in the earlier judgment of this court, that the prison authorities should ensure that the representatives are sent to the competitive authorities immediately after the receipt thereof. In the present era of technological development, the said representation can be sent through email within a day. It is further, this is important, it is further needless to reiterate that the competent authority should decide such representation with utmost expedition so as to the valuable right guaranteed to the detainee under Article 22(5) of the Constitution is not denied. In the matters pertaining to personal liberty of the citizen, the authorities are enjoined with a constitutional obligation to decide the representation with utmost expedition. Each day's delay matters in a case. Now, in our case, Lordship, it is a case where the petitioner was apprehended because it is alleged that some contraband were found in some vehicle, and that particular vehicle does not belong to me, Lordship. Nor the owner of the vehicle has been made an accused, nor there is any investigation with regard to the ownership of the vehicle, nor the ignition key has been seized from me. In such circumstances, the content of the FIR or alleged FIR, that is not red-handed, Lordship. It is alleged FIR. Even if there is a presumption, since it is an NDPS, even if there is a presumption that I am guilty, I have been caught red-handed, that is a matter of trial, Lordship. In NDPS cases, even if people caught red-handed, there are cases where they have been granted acquittal by the trial judge court or the High Court, Lordship, Honorable High Court. So in this case, Lordship, in this three-bench judge strength, Lordship, it is discussed even if the appellant is aware of the grounds of detention, our Constitution provides the inherent right of as provided under Article 21 and 22, Lordship. Thereafter, Lordship. Thereafter, coming to the next objection raised by the learned PP sir, that having prospective or retrospective effect of the judgment. the learned PP sir stated that Pankaj Bansal is a prospective, Pankaj Bansal judgment have prospective effect. To that lordship, Pankaj Bansal case, I have gone through the case and with my little understanding lordship, in Pankaj Bansal case, it has been stated that the grounds of arrest were conveyed to the accused person and the signature of the accused person were obtained in the arrest memo in presence of witnesses. Even then, he was granted bail. Why, lordship? Because a copy of the said ground of arrest were not furnished to the accused person. The grounds of arrest already known to the accused person, even then a copy not furnished, he was granted bail. It has been discussed in the judgment. May I? Pankaj Bansal in page number 93, lordship. Page number 93, I highlighted the paragraph. Pankaj Bansal was arrested on 14/6/2023 around 10:30 p.m. on the basis of the incriminating evidence. The written grounds of arrest were stated to have been read by Pankaj Bansal in the presence of witnesses, and thereafter Pankaj Bansal and witnesses signed on the same. However, lordship, and the observation of the court, arriving at the observation of the court at page 105.
Yes.
105, para 45, lordship. On the above analysis, to give the true meaning, a purpose of the constitutional and statutory mandate, section 19(1) PMLA of informing the arrested person of the ground of arrest, we hold that it would be necessary henceforth that a copy of such written grounds of arrest is furnished to the arrested person as a matter of course and without exception. In our case, lordship, even in this case, even since the copy was not furnished to him, he was granted bail. In our case, lordship, the arrest memo, the notice under section 50A and the WT, there is nowhere mention of ground of arrest, which itself is a violation of Article 42. And the submitting of the copy comes at the later stage. First, we will have to, the grounds have to be conveyed to us. And considering learned PP sir on the last occasion said that this judgment has prospective effect. Even if it has prospective effect, lordship, it has not been discussed anywhere in this judgment, it is prospective effect. I have submitted another judgment, lordship, where it discussed any judgment by the Honorable Supreme Court will have retrospective effect until and unless categorically stated to be prospective. I have the citation at page number page number 69, lordship. May I? Now the law of prospective and retrospective operation is absolutely clear. Whereas a law made by the legislature is always prospective in nature unless it has been specifically stated in the statute itself about its retrospective operation. The reverse is true for the law which laid down by a constitutional court, the law as it is interpreted by the court. This is the important part. The judgment of the court will always be retrospective in nature unless the judgment itself specifically states that the judgment will operate prospectively, which itself suggests that the Bihan Kumar, I am before this court on the strength of Bihan Kumar and Prabir Purkai's judgment, and which has a retrospective effect on my case. And having considered the same, the non-conveying of the grounds of arrest is a ground for me. It's itself a ground for me and also a violation of my private right, of my fundamental right, lordship. Thereafter, lordship, learned PPs are also raised the objection that some judgment in the Honorable Supreme Court is pending with some same matter, with the same subject matter. To this, I have annexed one judgment of on order of the Honorable Supreme Court on page number 73. This Mihir Rajesh Shah case. This is the case of rash driving, lordship. This is the case of rash driving, and in this case, it has been discussed that yes, in a case of rash driving, the appellant, the petitioner was arrested red-handed, as because Lordship there was CCTV footage, and he was caught disappearing of the evidences, and also he was absconding. So in such circumstances, the court was in a confusion state that if in such cases, bail should be granted on the violation of fundamental rights. To this also, the Honorable Supreme Court granted an interim bail. Your Lordship is well aware of that interim bail until the final order is submitted, until the final judgment is delivered, Lordship. I have annexed this, and it is on page number 77. Accordingly, appellant Rupesh Shankarlal Mange is directed to be released on bail during pendency of the appeal before this court in connection with the FIR, this and this, in page 77. So what I want to say, if my fundamental right has been violated today, right now, and as some judgment of the Honorable Supreme Court is pending, I cannot be held in the jail, behind the jail, because of my violation today, and I cannot be cornered till the judgment of the Supreme Court is delivered. So in such circumstances, the Supreme Court itself took a lenient view in granting interim bails, Lordship. In our case, Lordship, obviously the Lordship has granted bail to many of the accused in prior to this objection raised by the PP. So in our case, Lordship, I have been apprehended. I am in languishing behind the bar since 2 years, 2 months as of today. Not only Article 21 and 22, but also, 22, but also Article 21 has been violated in my case, because Lordship, out of 8 witnesses, 4 have been examined till date, and charge was framed somewhere on July 2023. Thereafter, as many as 21 dates, no witnesses turned up. There is no plausible explanation on the part of the prosecution that why no witnesses turned up for as many as 21 days, Lordship. Thereafter, on filing petition by the defense counsel, thereafter witnesses turned up, and till date only 4 witnesses have been examined, and which itself is a violation of Article 21, Lordship. And the BA number, the bail, I'm the coordinate bench of Justice Honorable Justice Kaushik Goswami has granted bail on the similar footing, Lordship. Even after the objection raised by the learned PP sir, I have the BA number, it is 472/2025. 472/2022. I do not have the order right now because it has been delivered yesterday only. The order has not been uploaded yet. And apart from this, the objection submitted by the learned PP sir, one case law was there, Om Prakash Trivedi. In that case, yes, bail was rejected as grounds of arrest were not conveyed. Because, Lordship, the petitioner in that case was himself an advocate, a legal practitioner, and he attacked a presiding officer of the court. In such circumstances, it is presumed that a layman would not have been known the grounds of arrest, but a legal practitioner will definitely know the grounds of arrest, Lordship. Thereafter, Mihir Rajesh Shah, which the Honorable Supreme Court has reserved, and based on which interim bail has also been granted. Thereafter, Ram Kishore Arora versus ED, submitted by learned PP sir, Lordship. In that also, para 16, there is written that the grounds of arrest in writing were handed over to the arrestee, and the arrestee has signed the said paper with his own language and stating that I have understood the grounds of arrest. In such circumstances, the bail was rejected. In our case, there is no grounds of arrest in any of the notice, nor in the arrest memo, nor section 50, nor WT message, as to whom the WT message was sent, to the relative, friends, family, whom, that is also not been conveyed. In such circumstances, Lordship, it is a clear case of bail, Lordship.
Okay, I'll hear your part.
Fine.
Martin Dobson, here. Suspended application. So you have received the objection filed by whom? Copy you have filed?
Copy also.
Otherwise, she basing on her the argument, principally the points raised by you
Yes, yes.
on that day, and those the citations which have already been submitted by you, just for 5 minutes.
Regarding constitutional mandate, to my knowledge, there is no constitution in England. There was Magna Carta in the 13th century. Subsequently, law was developed by Act of Parliament and the judgment passed by the House of Lords and courts. So that is their constitution is basically scattered, not containing into a particular one document. Unlike our constitution, or American constitution, or Swedish, or my lord, Swiss constitution. So my lord, that aspect, my lord, I have relied on the judgment to show that how the law has been developed. And that proposition has been taken by the Honorable Supreme Court in a same context in the judgment of Madhulimaya. Perhaps that was the first judgment. If there was before any judgment, I have no knowledge. In that judgment, taking proposition and taking help of this judgment of the House of Lords, Madhulimaya judgment was passed. Yes, there he was granted bail because the circumstances was different, the case was different. I was not placing Madhulimaya to show that they have tackled the issue of red-handed. They had not, my lord. Coming to my lord, Pankaj Bansal, Vihan Kumar, and Praveen Purkaisto, my lord, I am totally agree with those judgments. I am not conflicting with the judgment of Praveen Purkaisto or Vihan Kumar or Pankaj Bansal. That is why, because that is the law. But the thing is that those judgments, my lord, the issues were different. The person was caught in a different circumstances. Here, the person was caught in a different circumstance. So my limited argument is that, my lord, in view of that, my lord, those propositions cannot be implied here. Because here the person was caught red-handed. This section 15 notice was issued to him. He received the section 15 notice. Although there is no elaborate grounds of arrest, my lord, written there, my lord. But since it was his inconcise, then he is doing something bad. He is carrying the drugs. He knew, man. He was caught red-handed. So applying those principles will not help here. Because why article and the mind learner friend has relied on Nuraga judgment, I know. That is on a different footing. That was in a preventive detention case. That was Article 22(5). If I am not wrong, my lord, kindly peruse Constitution of India, my lord.
Constitution. No, it's okay. Anyway, you can.
My lord, I am reading, my lord.
Yes.
Because we are concerned with, my lord, Article 22(1). And my lord, in Article 22(3), nothing in clause 1 and 2, that means Article 22(1) and 2 shall apply to any person who for the time being is an enemy or alien, to any person who is arrested or detained under any law providing for preventive detention. So in that case, it was preventive detention. In that respect, this Article 1 and 2 will not come. So that is Nuraga. The second thing is that, my lord, yes, my learned friend is right. The grounds of arrest has to be given, but in what circumstances? Whether those judgments which my learned friend has cited discuss any point where a person was caught red-handed, that was not discussed. So, my lord, I'm again reiterating, my lord, where the person has been arrested red-handed, this will not come, my lord. And regarding, my lord, prospective and retrospective, yes, my lord, judgment will be applicable retrospective unless contrary, my lord. But here, this Ramkishore Arora, that itself is a Supreme Court judgment, said that Pankaj Bansal will come retrospective. And I have placed one High Court's judgment, my lord, of Chandigarh High Court, where it says that, my lord, Pankaj Bansal, Vihan Kumar, and Praveen Purkaisto, which will come prospective, my lord. And one judgment today only like to rely, my lord. Only one paragraph. There are 7, my lord. There is underlined, my lord. There are 7. Just only to show that, my lord. It is the rule deducible from the application of law to the facts and circumstances of a case which constitute its ratio decidendi, and not some conclusion based upon facts which may appear to be similar. One additional or different fact, this is important, my lord, can make a world of difference between conclusion in two cases, even when the same principles are applied in each case to similar fact. Here it is, to my understanding, my lord, if one additional fact or different fact can make a whole difference, my lord, applying the similar principle, my lord. Here, this is an additional circumstance, my lord. Additional fact, my lord. Even applying the principle of Vihan Kumar, there can be a different conclusion now. So this is my humble submission. Because I'm not saying that Limaya, they have discussed this thing. Nowhere where I have cited the case law, a learned friend has also cited law. I'm sure nowhere it has been discussed regarding what will happen if a person caught red-handed. Because Article 22(1) is for the person to know that why he has been arrested, and so that he can consult a legal counsel. Here he already knew before committing the crime, my lord. Or while committing the crime, he also knew. So in this case, my lord, as applying the principle of this House of Lords judgment, my lord, it's not applicable. And second thing is that it is also not necessary that police will have to give him immediately in the place of arrest. Yeah, I'm giving you grounds of arrest. It's not necessary. He can be arrested in the police station, that can be given there only. Right? That is also there. Right? But the thing is that here he knew and he was arrested. Right? And he was given Section 50 notice he received. So there is compliance. That's my humble submission.
May I, Lordship? With 2 lines. Lordship, as learned PP sir has said that our constitution, there is no cases of red-handed. Yes, it is true that our constitution is completely silent with regard to the thing of red-handed, as because, Lordship, it is still clear to the fact that any infringement, any slightest infringement in our fundamental right will directly invoke the right of the arrested person to, and is a case of bail, Lordship. And so far as the objection is concerned, Lordship, apart from every objection, Lordship, even then there is a assumption that I have been caught red-handed XYZ, I may be granted the protection of interim bail then, Lordship, until the judgment of this Honorable Supreme Court is reserved. Since, because this same matter, the red-handed matter is pending before the Honorable Supreme Court. On the same ground, Lordship, Mihir Raj, that is a heinous crime, drink and drive, crashing over a woman, and disappearing of evidence, even then he was granted the interim bail. Why not me, Lordship? In my fundamental right has been violated since the year 2023 to substantiate my claim. In 23, I was arrested. And my fundamental right has been violated since then in respect of this judgment. Mihir Shah, that case, that person was arrested maybe in a span of 1 year. Then if he is enjoying the right of interim bail, then why not me, Lordship? Why not on my part? I have not done anything so heinous, Lordship. And thereafter, Lordship, Arora, that what Arora? Ramkishore Arora case, Lordship. In that case, Lordship, PP sir stated that it has discussed that the Pankaj Bansal is prospective. Whatever it may be, Lordship. In my case, I have not been made aware of the grounds of arrest at all. In that case, Pankaj Bansal case, grounds of arrest were conveyed to the person. Whatever may be the circumstances, I have the right to be informed. Maybe on that particular point of time, the grounds were not served to me. But in this span of 1 year, 2 years, I am behind the bar for 2 years. In the charge sheet also, there is nowhere mention of the grounds of arrest. Why? Why the same has not been mentioned? Is there any note on that ground that for this ground, the grounds could not be mentioned to the accused petitioner. There is no plausible explanation from the part of the prosecution arresting authority. Even today, I am not aware of the grounds of arrest. That directly goes in favor of me, Lordship. This is my humble.
And regarding this Om Prakash Dwivedi case where the bail was cancelled, regarding they had taken the plea of non-furnishing of grounds of arrest. My learned friend said that the bail was cancelled because court held that he is a lawyer, so he knew. But that is not the ratio. Here it says that if you were about your action, there is no need for granting giving grounds of arrest.
The Om Prakash Dwivedi, Lordship, I have the judgment. I can read about the part where the Honorable Supreme Court has discussed that had it been a layman, the situation would have been different. But in this case, the person itself is a legal practitioner. And attacking a presiding officer in a court is itself a red-handed thing. In a court where there are witnesses. So in that circumstances, the bail.
There is no different set of fundamental right available for the advocate. Fundamental right is same.
My humble request, if keeping aside everything, I may be granted the interim bail till the judgment is pending before the Honorable Supreme Court. My right is violated today, since the year 2023, and in this on the similar footing, Lordship, coordinate benches are very are granting bail on the similar footing, Lordship. And I have the citation of long incarceration. May I submit?
No, it's
I have already
Long
stated, my Supreme Court has not fixed any minor particular time limit, and there are two things, one is long incarceration, and second is there is no possibility of concluding the trial because this aspect first came from the Muhammad Muslim case. Those 2 points, after examining those 2 points, Supreme Court held that this is a prolonged incarceration. In that case, my lord, the petitioner, I forgot, my lord, that a petitioner was around for 5 years and only 7 witnesses were examined out of 20 or 30 witnesses. Here, my learned friend also submitted out of 8 witnesses, 4 already examined. So from that angle also, my lord, your lordship has to look into whether there is any possibility of concluding the trial and long incarceration.
In these circumstances, Lordship, there has to be a reason as to why for long 21 days, 1 year, the prosecution witness did not appear. At that point of the, had the prosecution would have witnesses appeared on the period of 1 year, my trial would have been concluded till this point of time. I am still today, I am languishing behind the bar because on the discrepancies on the part of the prosecution agency. My humble request is there any condition, Lordship?
judgment is reserved. Order is reserved.
My lord, subject to your lordship's permission. Subject to your lordship's permission, though my lord, I am not a part of these proceedings, my lord, I want to indicate one aspect of the matter. Being a stakeholder, my lord, because similar petitions, my lord, are pending. There are 2 cases, my lord, where I have appeared. Those 2 cases are fixed on 8th, my lord. Now, what I understand that the fallout of this proceeding would have a bearing, my lord, on the other applications. If I have rightly understood, my lord. So, my lord, when I would, if the, my lord, this, the judgment or the ratio, if it goes in favor of the petitioner, I would have no problem, my lord. But if it goes against, my lord, the petitioners, then the only remedy which would be open, my lord, is the Honorable Supreme Court. Because your lordships, my lord, would not be reopening, my lord, the case again and again. So therefore, my lord, my respectful submission is, my lord, being a stakeholder, the petitioners, my lord, which they have filed the bail applications are on similar ground. That the ground of arrest, my lord, was not, my lord, made available to them.
So therefore, my lord, my humble submission is, at least, my lord, I am entitled to a copy of the public prosecutor. And my lord, a date, my lord, your lordship may also give me an opportunity to, my lord, submit on that point, my lord. I think, my lord, on the ground of propriety, I leave it to your lordships, my lord. I'm making a prayer, my lord. My cases are fixed on 8, my lord.
Then-
So if your lordship, my lord, in the meantime, if your lordship does not deliver the judgment, so lordship may allow us, my lord. I don't know with regard to other advocates, my lord. So far as I am concerned, my lord, lordship will also give me a, my lord, chance or opportunity to place, my lord, my submissions in this regard. Because there are
In that
interpretations.
case, you're saying that it should be reserved up till 8 or 9.
No, your lordship can take up in between also, my lord. I can
No,
give
we
the
don't
bill
have-
application.
We don't
numbers,
have
my
any
lord.
space. We don't have any space.
Yes, correct, my lord. I'm only making my prayer to that effect, my lord, because I'm a stakeholder in those cases, my lord. My petitioners, my lord. Because I would be denied the opportunity of being heard. Because in the meantime, if the judgment comes against, my lord, the petitioners, then, my lord, the consequence will follow, my lord. Only this much, my lord.
Okay, till now we are reserving the order.
My lord, deeply.
Let that be adjourned for today. Only we'll go for item number 11. 14 and 24.
So it will record to open.
I don't see
It will give up of details. Yes. And see afterwards. I can do it.
P, Lordship, Lordship, with regard to item number 14 and 28, the same similar footing, the both the matter may be adjourned for the today until the judgment of this.
So we'll list after 1 week. Let us see what happens. 14 and
14 and 28.
14 and 28. Both 14 and 28 I don't put the request and so. List after 1 week. Okay, where is it?
30.
NDPS case.
Hmm.
One of the FIR you will find page number 9. This FIR is, my lord, 8 of December 2022. And as per the allegation in the FIR, my lord, 2 vehicles were coming from Dimapur side. Both the vehicles were intercepted at, my lord, under Karbi Anglong district, my lord, in the Karbi Anglong district by the, my lord, by the Kotkode police station. And from the 2 vehicle, my lord, some, my lord, Uber tablet, my lord, containing total, my lord, some plastic bag were found, my lord, in the vehicle. And here the present petitioner, my lord, total 4% were apprehended by the police, my lord, and out of the 4%, the present petitioner, he was a helper of one of the vehicle. And even he has been shown as a helper also. Lordship will find page number 27 in the charge sheet portion, my lord. No, my lord, page number, sorry, my lord, page number 25, my lord.
25.
25. Particulars of arrested person charge sheeted, my lord. Here, Lordship will find the bottom para 2, my lord. The name of the present petitioner is shown, my lord. Muhammad Islamuddin. Here, my lord, the last 3 lines from bottom, 4 line, my lord. Column 11, my lord. Occupation helper, my lord. Here, my submission is, my lord, the petitioner was traveling in one of the vehicle. And from that vehicle, my lord, the police, my lord, allegedly recovered some contaminated substance, my lord. Measuring total, my lord, 757.15 gram of, my lord, heroin, my lord. Now, my submission is, my lord, the petitioner was traveling in that vehicle, my lord, as a helper. The petitioner did not have any knowledge what the materials were there or what contaminated substance were there in the vehicle. Now, police also has not shown me as a, my lord, my implication also, police also has not indicated in this charge sheet, nor in the FIR, my lord.
The petitioner is behind the bar for, my lord, as on today, my lord, 873 days, 2 years, 4 months, 21 days, as on today, my lord. And out of the total listed witnesses, my lord, 4 have been examined, my lord.
How
So for
many?
the 4,
How many listed witness?
my lord, 6, my lord.
6.
So for the on the revised, my lord, my learned public prosecutor, my lord, informed the court, my lord, that one more I have submitted here 3 witnesses, and one more has been examined in between, my lord. Now my submission is, my lord, the petition is behind the bar for 2 years, 4 months, 21 days, and petitioner was not in conscious position. The petitioner did not have any conscious position, consciousness or conscious knowledge, my lord, about the, my lord, the contents or about the, my lord, material those who were, my lord, carried in the vehicle, my lord. Now whether, my lord, now, my lord, I'll place 1 or 2 judgment of the Honorable Supreme Court, my lord. One judgment, my lord, in one of the judgment, my lord, this court, my lord, did not consider the bail application. That matter went to the Honorable Supreme Court, and the Honorable Supreme Court granted bail to the petitioner, my lord, only after 1.5 years, my lord. And I'm placing the judgment. And another judgment, my lord, here also this court, my lord, granted bail to one of the petitioner, my lord, who in that case, my lord, the petitioner was behind the bar for 2 years, 5 months, my lord. That's why I'm placing these 2 judgment, my lord. But here, my lord, this Biswajit Biswas versus State of Assam, my lord. This is the case, my lord. Here, Lordship, I have to read the judgment, my lord.
No, it's okay.
My lord, the order portion. Petitioner is accused in a case bearing official NDPS case number shown arising out of PS case number shown for the offence punishable under section shown 22C, 25, 29 of the Narcotic Drugs and Psychotropic Substance Act. The bail application of the petitioner was dismissed by the High Court. He had already undergone 1.5 years in jail. Our learned senior counsel for the petitioner and the respondent state. Considering the fact that he is the driver of the vehicle and he has no other criminal antecedent, and also the period of incarceration of the petitioner, we are of the opinion that a case of bail is made out for the petitioner, my lord. So here, my lord, the petitioner is behind the bar for 2 years, 4 months, my lord. Almost 2 years, 5 months, my lord. 2 years, 4 months, and 21 days, my lord. And the petitioner was simply a helper, my lord. Neither he is the driver, nor the owner of the vehicle, nor even the, my lord, the even owner of the goods those who are carried in the vehicle, my lord. Even the police also has not implicated me. Thank you, my lord. The carrier of the goods, my lord. Police also has not, my lord, shown my direct involvement in the, my lord, offense that has been, my lord, allegedly, my lord, pointed out by the police, my lord. Here, the vehicle was intercepted. I was, my lord, traveling in the vehicle. Driver and co-driver were also arrested, and I was in the vehicle, and I was also taken into custody, my lord. That is the, my lord, the case here, my lord. I have no knowledge what the materials were there in the vehicle. So, my lord, on this ground, my lord, my petition is to be considered, my lord. And secondly, my lord, in another case, my lord, this court, my lord, this granted bail to the petitioner after 2 years, 5 months, my lord, relying on the judgment of the Honorable Supreme Court in Ravi Prakash versus State of Odisha's case, my lord. Lordship, the second judgment, my lord. Here also, this court, my lord, took the view that since the petition is behind the bar for 2 years, 5 months, and the, my lord, the trial was supposed to take, my lord, longer time. So ultimately, on that ground, my lord, this court granted bail. So this is my submission, my lord, considering the my lord, decision of the Honorable Supreme Court in the first decision, my lord, that I have, my lord, submitted, my lord, in, my lord, Biswajit Biswas case, my lord, this bail application is to be considered. That is my submission.
Already submitted, my lord. Out of 6 witnesses, 4 have already been examined, my lord. Last PW4 was examined on, my lord, 11 to, my lord, in the month of February, my lord. And, my lord, the present status of the case is not, my lord, up to that status report is not available, my lord. But, my lord, maybe, my lord, other 2 witnesses also might have been examined. And my lord, PW 2 and 4, my lord, both the PW 2 and 4, they have implicated, my lord. And it is not that, my lord, if the accused person has no knowledge about the, my lord, contraband, my lord. It was his knowledge, my lord. That is why, my lord, case was registered, my lord, under section 21C, 22C, and 29 of the NDPS Act, my lord. So my humble submission, my lord, this is not a fit case, my lord, to grant his bail at this stage, my lord. Because there cannot be any prolonged incarceration, because, my lord, out of six witnesses, 4 witnesses have already been examined as on, my lord, 11/2/2025, my lord. So till now, my lord, maybe, my lord, some other witnesses also might have been examined, my lord. And this is a, my lord, commercial quantity, my lord, rigors of section 37 will be there, my lord. I oppose this bail application.
And only three points, my lord. One is, my lord, conscious position, my lord, whether the petitioner had the conscious position, my lord.
But it is a clear case of Nawaz Khan, my lord.
And
In Nawaz Khan
secondly,
case also, my lord, he was in the, my lord, vehicle, but it was his knowledge, my lord.
the first is the ground whether he had the conscious position. Second is the, my lord, length of detention, my lord. Since the petitioner is banned for 2 years, 4 months, my lord, for 2 years, 4 months, and 21 days. And third is the, my lord, the longer in the trial, my lord. These are the three grounds.
I have already noted down some portion here. You have already noted down. Oh,
All right.
May it please your attention. 483 application. In this case, the petitioner was arrested on 29/11/2022 under section 20B2C, where 19 packs of ganja was recovered from him. Not from him, but ganja was recovered in the case. What is the mainly, your lordship, what has happened in this case is that my contention will be on 2 grounds. One is with the case of long incarceration, and secondly with ground of non-furnishing of the grounds of arrest. That normally it is been argued, your lordship, all the time. Now here, your lordship, there are 19 listed PWs. Out of 19 PWs, only 6 witnesses have been examined. And your lordship, that too, he was arrested on, your lordship, 29/11/22 itself. And then, your lordship, now it is about 2.5 years, nearly 2.5 years, your lordship. And in this period, only 6 witnesses have been examined out of the total of 19. So that is the first ground on which, your lordship, I am saying. Now, the last witness which was examined was on 21/8/2024. That is nearly 8 months ago. In fact, there was a court's order while initially in another case, in fact, in another case, the court had ordered, but from the same FIR, the court ordered that the trial should be done expeditiously within a period of very expeditious, that I have annexed. And that was also not. In fact, after the passing of that order by this honorable, not a single witnesses have been examined till date. So that is one ground on which, your lordship, I would like to point out. Second point, your lordship, with regard to the witnesses itself, I am pointing out, all the witnesses that were examined were official witnesses of the NC. Not a single independent witnesses have been examined till today. Therefore, your lordship, in this case specifically, I urge that the petitioner is suffering long incarceration, which is in violation of Article 21 of the Constitution. I'll submit the judgments. In fact, there is a judgment by your lordship itself, wherein in 2 years, 5 months, where there were 8 witnesses, 4 have been examined, your lordship has granted bail on long incarceration. Here is 19 witnesses, out of which only 6 for the last 2.5 years. And that judgment I can give because your lordship in that judgment has referred so many other judgments from, I think, Muhammad, Muslim, then Ravi Prakash, etc. Everything has been discussed. Satyendra Kumar Antil and all, everything has been discussed. That I'll place. That is one on the first part, first ground with regard to long incarceration. I'll pass the judgments later on. I'll first make my argument. Basically, in this case, what has happened, your lordship? Your lordship will kindly take up page the petitioner was actually intercepted in a truck, from where in the cabin of the truck the ganja was recovered. This amount of ganja was 119 packs were recovered, from where the total along with the pack it was 195 cases. So that is the interception, and the petitioner was ultimately arrested. Now the second part is with regard to the no grounds of arrest that has been provided under section 50 of the CRPC as well as 47 of BNSS, which is violation of Article 22(1). So these are the two grounds on which. First ground, long inculcation, your lordship. In that, with regard to the long inculcation, your lordship, I'll just provide your lordship judgment. Your lordship, in that case, has given it on the long inculcation was on the basis of period which was 2 years, 5 months. And in that case, your lordship, there were 8 witnesses. Out of 8 witnesses, the lordship has 4, I think, was this is a judgment. I'm not placing the Muhammad Muslim, Ravi Prakash and all, just I'm placing this judgment. The lordship will kindly take up first. Here, your lordship will kindly take up para 12. Para 12, your lordship, para 12. In that judgment, lordship judgment, para 12, I'm just pointing it out. In that case, your lordship, it is the case of the petitioner, the accused is in custody for more than 2 years, 5 months, 21 days. Here it's practically the similar, nearly 2 years, 6 months. The prosecution could examine 7 witnesses out of 11. In that case, 7 witnesses of 11 has already been examined. In my case, out of 19, only 6 in about 2 years, 6 months. The prayer for bail for considered. Further, it is the case of the petitioner. There is no probability of the disposal of the case within a short or reasonable period of time. So this is also the same here. Your lordship will kindly turn to then paragraphs 19 onwards. Your lordship will kindly see in the same case. 19 onwards, your lordship has referred to Ravi Prakash, Sitta Viswas, Nitish Adhikari, Sariful Islam, Salman Hanif, Parnell Singh, Anjan Nath and all, and ultimately your lordship on the basis of that fact has granted bail, and that is at page 27, para 27, page 12. So this matter, your lordship, is in fact I am in a better footing than in this case, your lordship. So the petition is otherwise entitled to granted bail under section 21 because of the violation of section 20, article 21 of the Constitution. Second part, your lordship, with regard to the grounds of arrest, that was not provided to the petitioner. There has been a long argument that was going on. I was here. I've heard it. My learned lady friend has argued very well. Just pointed out everything. In fact, the issue that is the only 2-3 points which she has not made, I'll just make, because lordship has already heard her, and also my learned friend Rishi Kaushik has also been heard. So basically, what was the point they are trying to point out is that when there is a judgment is passed, it is mainly in a fact that they say it is to be on prospective effect. But there is a judgment which they have already submitted, case of to Kanishk Sinha. The Supreme Court says normally a judgment is retrospective when it is with regard to the constitutional provision. It may be prospective when there is a legislation that comes up, because there may be some new legislation coming up, something new coming up. In that, yes. So in that case only, it becomes on the date prospective, the day of notification. In fact, your lordship knows that the notification of the judgment, notification of the legislature has to be notified in the Gazette only after that. It comes into effect, and therefore that judgment becomes possible. But if a constitution of India is long back, your lordship, the constitution has added something. The constitution prevails over all the other acts and rules. Therefore, it is supreme. So being the supreme, if there is a specific ground of constitutional provision given, then that must be followed And there cannot be any other, your lordship saying prospective or retrospective cannot come. That cannot come at, the judgment itself is very clear, saying that in a constitutional provision, there cannot be. In para 3, your lordship, in that case, paragraph 3, the court has very specifically stated, yes, in cases of legislature coming up with an act or rule, it may be different, it may come up prospectively, but in a case of constitutional provision, it cannot be retrospective at all. So that is one ground which has been decided by the Honorable. Second part, your lordship, which has not been argued at all, was with regard to the case that was the case of yes, no, Bombay case, Ravi case. Just a minute. The case which was basically referred now, which was referred to, was that in the hit and run case, this has happened, and the court has reserved a judgment. The judgment I have also gone through. The order that was passed was that the court will consider the written arguments submitted by the parties. These issues were also taken up, and it will be decided. Until then, there were two petitioners, the mother and the son. Both were, one was 10 months, one was 8 months, and the court, considering the length of detention as incarceration, has granted bail to both of them. They were in jail. They were given interim bail till a decision is made. This decision will come much later, your lordship. It will not come as soon as possible, because there will be the judgments and other things has to be provided, as well as the written arguments to be submitted by the parties in that case, in the Honorable Supreme Court. Now my question is that when your lordship, the case of Bihan Kumar, your lordship has gone through that case most probably many times. In case of Bihan Kumar, there are very many paragraphs. I can read those if your lordship wants me to. I'll read those paragraphs. That has been specifically stated how and what the court has to do. Specifically in paragraph 31, that is the last paragraph of the first. There are two parts of the judgment, your lordship knows. One was passed by Justice Oka and the other was passed by Justice Kateshwar Singh. So Justice Kateshwar Singh added to what Justice Oka has passed. But the last, not last, paragraph 31 of that case specifically indicates, which I will read up. I think the judgment is there, or I will provide it.
I have the
judgment. I'll just read that. Here, your lordship, what the court has said in paragraph 31 is very important, because that is a direction to all the courts of the country. I'll just read. The learned single judge unfortunately has equated information given regarding the appellant's arrest with the grounds of arrest. The observation that the allegation of non-supply of the grounds of arrest made by the appellant is bald allegation is completely uncalled for. This is the decision of the High Court, which the court is interfering. All courts, now your lordship, this is the direction by the Honorable Supreme. All courts, including the High Court, have a duty to uphold fundamental rights. Once a violation of fundamental right under Article 22(1) was alleged, it was the duty of the High Court to go into the said contention and decide in one way or the other. When a violation of Article 22(1) is alleged with respect to the grounds of arrest, there can be possible two contention raised. One is that the arrested person was not informed of the ground of arrest, or B, purported information of the ground of arrest does not contain any ground. Here in this case, you know, so my case, in fact, the second part comes because here the ground of arrest section 50 a notice has been given to me, but that does not purportedly given the grounds of arrest. So these are the two things the court has to do. As far as the first contention is concerned, a person who is arrested can discharge his burden by simply alleging that grounds of arrest were not informed to him. If such an allegation is made in the pleadings, the entire burden is on the arresting agency or the state to satisfy the court that effective compliance was made with the requirement of Article 22(1). Therefore, the view taken by the High Court is completely erroneous. So, High Court cannot go beyond that. So, only thing the High Court can go whether the grounds of arrest under Article 22(1) requirement. In fact, in this case, it's an NDPS case. It is stated in Section 52(1). It has been stated in Section 52(1). So, ground of arrest has to be provided to the accused. Now, whether that has been provided or not, if it has been provided, whether the notice under Section 50 or 52(1) or 47 BNSS, whether that complies with Article 22(1). That is the only lookout for the Honorable High Court as directed by the Honorable Supreme Court. So that is the only part which remains to be seen by a High Court in a case where the allegation is with regard to the grounds of offence. Further, nothing else have been directed by the Vihan Kumar. Now, after Vihan Kumar, another one or two judgments have come. I'll also place those judgments. I don't know whether that has been placed or not. Where the Supreme Court judgment, I'll place. One is prior to that, two. I think Bansal is prior to that. Then comes Pravi Prukast, then comes Vihan Kumar. So Vihan Kumar has a direction that has been specifically issued, considering so many other judgments, and then came to a finding that 22(1) must be complied. It is not a word that any other. Now there can be differences. What I heard, there is some differences with the state of particular case, or the act committed by a particular person may be different in different context. But overall, the High Court will have to see only one, whether 22(1) has been complied with or not. If it is complied with, very well, your case goes, nothing remains. I have no further argument. If it is not complied with, there are two grounds. First is whether it has been given to you. If it is not given, goes. If it is given, the court will see whether that's satisfied Article 21 or not. If it
No, but the question is they raised by Mr. Kaushik is that in regards to only the caught red-handed. In your case also, most probably your position was recovery was from you.
Yes.
Because from the vehicle.
It was from
that
the
is
vehicle.
the issue raised by the prosecution.
That was one.
In that context, what you want to submit?
That part, red-handed part, was already, I think, taken up in that case of the Honorable Supreme Court. That which now what happens, Your Lordship, whether caught red-handed, not red-handed, will come later on. Your Lordship's part, I'm just pointing out what the High Court will have to look as per the judgment of Vihan Kumar. And I'll also give another judgment where the court will say that I will come later on. Here, the court has specifically said what is the role of the High Court. Role of the High Court 21 violated or not, facts, forget about the facts. That is why I'm saying two more judgments I'm placing. Three judgments, in fact, which were not placed. So in these judgments, the Vihan Kumar, I'm saying, Vihan Kumar specifically says that the High Court has a role to see whether it has been given or not. Now, if somebody says that this is a red-handed, somebody will say this handed, that handed, or he has been arrested somewhere else. Factual part, Your Lordship, we cannot go into the factual part that the court has all throughout said in this, that your role is only to see whether 22(1) has been violated or not. If it is violated, nothing else. If it is not violated, then your case goes. Facts, red-handed, not red-handed. The case that is at hand of the Bombay hit and run case, that is one case where this part may come up and court may pass an order, but it has not been passed. Nothing has been done in that case. Till that order has been passed, till a judgment comes from the Honorable Supreme Court, what is the role of the High Court? That will come into a question in your Lordship's mind. What will I do? That is why I'll come into another judgment, which is the judgment of your Lordship. The Supreme Court judgment wherein Union Territory of Ladakh versus State of Haryana. This is reported in 2023 SCC Online SC 1140. This is practically the case of the Honorable Supreme Court, where Supreme Court is very clear. Lordship will straight away turn to paragraph 30, is a very long judgment.
We are supplying Vihan Kumar. Other one?
No, A to D9. Ekon ki dila. No, Vihan Kumar, no, Ekon. Excellent. Just a moment, Lordship, I must have. Oh, this, sorry. Vihan Kumar from Nalai.
We have the Vihan Kumar, I think.
Sorry, so many judgments. I'm also I am running from one court to another, Your Lordship.
Yes.
Yes. This is 2023 SCC Online SC 1140. This is the case of Union Territory of Ladakh versus Jammu and Kashmir National Conference. This was on September 2023. Lordship will straight away go to paragraph 35. That will Lordship will see at page 17. Below is the pages given, 17 page. I'll just read this. I can read the whole judgment, but I'm not reading it because Here it is very strict order passed by the Honorable Supreme Court. Very strict. That is why page 17, para 35. We are seeing before us judgments and orders by high courts not deciding cases on the ground that the leading judgment of this court on this subject is either referred to a larger bench or a review petition relating thereto is pending. Here it is not a review petition or it is not referred, but is a case where a judgment is reserved. We have also come across examples of high courts refusing deference to judgments of this court on the score that a letter coordinate bench has doubted its correctness. This is also very clear. In this regard, we lay down the position in law. So position in law has been laid down. We make it absolutely clear that the high courts will proceed to decide matters on the basis of the law as it stands. It is not open unless specifically directed by this court to await an outcome of a reference or a review petition, as the case may be. It is also not open to a high court to refuse to follow a judgment by stating that it has been doubted by a later coordinate bench. In any case, when faced with conflicting judgment by benches of equal strength of this court, it is either one which is to be followed by the high court as held by 5-judge bench in National Insurance Company versus Purnai City. The high court, of course, will do with careful regard to the facts and circumstances of the case before. So what the court directs is that it is must. It is a direction that the law which is clear at that point of time must be followed. Now, no other law has come up. If they can show, somebody can show, no, some other coordinate benches have given some other judgment, then that is a different aspect. Here's a case which the law has never been laid down. Nothing has been done. Already the law which has been laid down from Madhu Limai onwards, 1968. Madhu Limai, my learned friend, Kaushik has pointed out Madhu Limai's case with regard to the Constitution of England, which will not be applicable here because there is no written Constitution of England, number one. Second part, there also in that case, section 22(1) of the article was upheld, number one. So, the case of Madhu Limai, if I don't refer even Bihan Kumar or all these cases and I go back to Madhu Limai, Lordship, as per Madhu Limai, my case is covered. Then what happens? In 68 itself, this law is there. In fact, it's a constitution provision. It's have to be upheld. In 2025, who is going to question a constitutional provision? Secondly, when the law has been from Madhu Limai till today, is been laid down in a similar fashion. There is no case where it is said that you cannot follow 22(1) in a case of red-handed or in a case of XYZ. Then, where is the law? The law is laid down by Vihan Kumar, Pravi Pukastov, Pankaj Bansal, Madhu Limai, etc., etc. There are some other cases which has also been referred. I'll also refer to other judgments. In that case, Your Lordship, what is the direction of the Honorable Supreme Court? You must follow. You have no other options. This is the direction, Your Lordship, because the High Courts court has specifically stated the High Court is doing this, that, this, that. That is why I brought this judgment, because there is sometimes even being Your Lordship, assisting Your Lordship. I know there sometimes it comes to a mind. What will happen if I'm going to give bail to so and so many? That is the lookout. The Supreme Court has given it. If there is an issue, the state will go to the Supreme Court, say this is the issue. Now these are bails are given to cases. Something has to be done. Court will do it. But till then, what is the lookout? The court has specifically stated in various cases that the judgment of the Supreme Court you must follow in toto. You cannot go and say the coordinate bench this, that. No. And in this case, there is no other judgment, except the fact that there was a case which has come up, hit and run case, where the judgment has been reserved. The court says, what is the judgment at present is running, that has to be followed. What will come, you don't have to look into all that. This is the reason, and there is a specific direction in paragraph 35. Now, Your Lordship will kindly see, with regard to facts and circumstances, when you come, there are other facts, for example, like red-handed, this and that, that will not come. When there is a violation of 21 and 22, court will only see that. This is a recent judgment. I'll just produce that judgment. A case of Directorate of Enforcement versus Subhash Chandra. This is 2025 SCC online 240. Here I'll just take your lordship to paragraph 8. What is the court's duty? Again, it has been given here. What? Paragraph 8, second page. Yes. Once a court, while dealing with a bail application, finds that the fundamental rights of the accused under Article 21 and 22 of the Constitution have been violated while arresting the accused or after arresting him, it is the duty of the court dealing with the bail application to release the accused on bail. The reason is that the arrest in such cases stand vitiated. It is the duty of every court to uphold the fundamental right guaranteed under Article 21 and 22 of the Constitution. Therefore, when arrest is illegal or vitiated, bail cannot be denied on the ground of non-fulfillment of twin test. This part is with regard to PMLA, and in same case, it is 37 with here. That will not come. But when the court, there is an argument or there is specific, if the court finds, even if I don't argue your lordship, if I don't argue on the point of ground of arrest, if your lordship finds that there is a violation of Article 21 and 22, in this case, both are violated, then in that case, your lordship has nothing else to do but to grant bail. What happens in trial? That will happen. That is a separate issue, we'll not go into. But as of now, when a bail application is filed, your lordship, if there is violation, the violation is there, bail, nothing else, your lordship. Then one more judgment of the recent judgment, your lordship. After the judgment of Vihan Kumar, very short judgment. Assis Kakkar versus Union Territory of Chandigarh. I've just marked that paragraph, third paragraph. Paragraphs are not given here. Recent judgment. We are, and there were many other, your lordship, grounds taken in that case, first two paragraphs. Third paragraph I am doing, when the court says that I will go only with one ground. Why? That has been stated. We are, third paragraph, we are inclined to consider only the last issue raised by the appellant with respect to non-furnishing of the grounds of arrest. Upon perusing Annexure P3, we can see that what has been provided to the appellant is only an arrest memo in the prescribed format, which is meant to be given to the appellant by way of an intimation. It has been filled up with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based on the statement of co-accused. We are in agreement with the submission of so-and-so made by the learned senior counsel appearing for the appellant, and the said arrest memo cannot be construed as ground of arrest, as no other worthwhile particulars have been furnished to him. That this being a clear non-compliance of the mandate under Section 50 of the Code, which has been introduced to give effect to Article 22(1) of the Constitution, we are inclined to set aside the impugned judgment, particularly in the light of the judgment written by this court in Parveen Pukasta Swens. In view the matter, the impugned judgment states that the arrest of the appellant followed by consequential remand order is satisfied. So what? These are subsequent matters, and that too by the Honorable Supreme. The Supreme Court says that we will not go into other parts. When the ground of arrest is there, he has not been given. He has given a memo of arrest where nothing has been written except name and address. So that is not complied. So what the Supreme Court has also not dealt with this. Why? Because it is a constitutional provision. Again and again, the same term has been put up that when there is a constitutional provisions, you cannot go into facts and circumstances of each and every case. You just go into the constitutional provision, you see whether fundamental right is violated or not. If it is violated, bail. If it is not violated, no bail. Then it will come with regard to facts and circumstances of the case and other things. Trial will go on. The court in Prabir Pukasta as well as in Vihan Kumar has stated that trial will continue. You will have to face the trial. And after trial, if you are convicted, that's a separate issue. Bail is a separate issue. And your lordship knows the rule. Bail is the rule. Jail is not the rule. That part, I'm not making any submission, but these are the facts, your lordship, where lordship will have only the lookout with regard to the fact, not with the fact of the case. When there is an allegation of violation of fundamental rights, your lordship does not go beyond that. Your lordship will have to stick. If your lordship sticks and finds out violation is there, no other option. These two cases, very specifically, I think ED, Enforcement Directorate case, as well as the case of Lada, they're very specific. 22, 21 violation go, and second is with regard to when there is a judgment already going on, which is in vogue, you have to follow that. Subsequent judgment will come pending, or the review matter has gone to a larger bench, that will not help. You just have to follow which is already given and which is on record is the law at that point of time. Now the law is Vihan Kumar, because the latest judgment, Vihan Kumar. And if your lordship also thinks that no, I'll not go by Vihan Kumar, Prabhu Prakasto, no, I'll go by Pankaj Bansal, no, I'll go by 1968 Madhu Limaye. Lordship can go to Madhu Limaye and say, where's the question of going that at that point of ground, whatever be the reason. Main ground of bail was on 22(1) itself. It was not on any other ground. 22(1) constitutional provision violated bail. What facts? Forget the facts. That is what exactly is what I'm trying to point out. I have given the facts of my case, because my facts of my case, red-handed, that will not come at all. In any case, whichever case comes. Yes, tomorrow if there is another law laid down by the Honorable Supreme Court, your lordship will have the handle to position your lordship into a different stand. But as of now, making submissions, I understand they also have the, if I would have been there in the other side, I would have made some more submissions, making confusion in the mind of the court. That I would have also done. But that cannot help, because these are, if your lordship, this matter goes back to the Honorable Supreme Court with the direction where in the case of Ladakh, by Union Territory of Ladakh, when we saw the court, that lordship, see what is the High Court doing, going by red-handed, this-handed, where is it specifically stated that you have to follow the law which is laid down at that point of time. What will the Supreme Court say, your lordship? Just that is mandatory, your lordship. That's the basis of the whole case. Factual part will come later. Person arrested, grounds given, not given, go. That's it.
Yes, you may make your submission at 2. Otherwise, have you filed any written here? You're going to submit verbally only? All submission will do?
File my written submission in the on tomorrow, lordship. Regarding the
So we have
objection.
heard at a length, Mr.
Lordship, I
Vandandan.
will make my oral submission today. Also, regarding the objection, I will file it tomorrow. I have communicated it to the department. They are going to send it today only, lordship.
Earlier, they have already taken twice time to file objection.
Make your submission, oral submission then.
Same
Okay,
thing, I
and
can make it
otherwise also, if you stick on this, the grounds of or the specific allegation against those, and that because I have seen in many cases of NCB or DRI, these grounds are there in regards to what is the case against this one and what is the case against the other accused, and these are there. So if it is already there, then you can make submission from here also. And if in that case, if you again see that there are some other materials to be placed through in written form, then it's okay. Otherwise, we can hear you at 2. So you make your submission at 2. After that also, if you feel that no, there should be a written submission, then we allow it. Otherwise, you make your submission today also. At 2, we are going to hear.
Lordship.
Yes, Mr. Jain. 50.
In this case, the petitioner was arrested on 29/11/2022, lordship, and the charge sheet was filed on 25/5/23. And the charge
25/5.
25/5. And the charges were framed on 22/9/2023. 22/9/2023. And as of now, 6 witnesses have been examined out of 16.
19.
Out of
19.
19, Lordship. Now, Lordship,
19. It is already there in
it is
the
also
charge sheet, 19 witnesses, not 60.
subject to correction, Lordship. Now, Lordship, may be pleased to come to page 42 of the bill petition.
Yes.
Lordship, para 9. Third line. On asking the petitioner Ganesh Kumar, he has admitted that 19 packets of ganja are concealed inside the driver's cabin and concealed in the upper portion of the cabin in a specially made selling of the truck bearing registration number so and so. On request, the Ganesh Kumar, the present petitioner, also the driver of the container, opened the ceiling by the screwdriver and bring out the packets of the suspected ganja, which were concealed in the special made cavity inside the ceiling over the driver's cabin. And there are total 19 rectangular shaped packets which were bring out by Ganesh Kumar and unloaded from the truck, bearing registration number so and so. On asking, he admitted that the 19 packets containing ganja. All the packets were cut open and the packets found to be containing flowering tops suspected to be ganja. A small quantity was taken out and it was tested. Then it gave positive test for ganja. Lordship, then para 11. The total weight found to be 195.71 kg. Now, Lordship, may come to page 44, para 16.
Page 40.
Page 44. Para 16. That on questioning of the suspected, Ganesh Kumar admitted that he was consciously involved in the trafficking of ganja for monetary benefits and he was going to deliver the consignment of ganja from Tripura to Bihar. He also told the receiver of the seized ganja is Lakshman Roy, who is also the co-accused in this case. And the supplier of the seized ganja, namely Rajiv Roy, are coming to escort him, en route him, and will reach the Madarpur toll plaza within 3 hours. Now, Lordship, may come to role of the present petitioner, that is on page 65.
Yes. 65.
Role and evidence arrested accused Ganesh Kumar. 105, para number, it's number 1. That a seizure dated so and so was seized from the container bearing truck registration number so and so from the conscious position of Ganesh Kumar. That Ganesh Kumar was the driver of the truck containing the seized ganja. Now, Lordship, para 3, next page. That in the statement made by him, Ganesh Kumar admitted that the Lakshman Rai directed him to load ganja, for which Lakshman Rai promised to pay him rupees 50,000, for which Ganesh Kumar agreed, and also disclosed by Ganesh Kumar that at Chuarabari gate, Rajiv Roy sent one person to Ganesh Kumar to load the ganja. Ganesh also gave the container number bearing registration number so and so and the person to load the ganja. And on 28/11/2022, the same container was registration number so and so was returned to Ganesh Kumar after loading the consignment of ganja. And para 4, Lordship, that he stated that the ganja was to be delivered to Patuna, Patna, Bihar to Lakshman Rai. That also, Lordship, it is important that CDR is also there, and it has been found that he was in constantly touch with the other accused persons, Lordship. So there are sufficient materials against him. The ganja was recovered from the conscious position of the petitioner. Now, Lordship, may comes to this is a order dated 12/12/24. The bail of the co-accused person has been rejected by Honorable Mrs. Alasi Nanji.
His bail prayer or co-accused?
Co-accused.
Co-accused.
We have annexed that. Annex page 102, annex.
Mr. Wells, this order contains all the submissions made by both the parties and his bail was rejected. Lordship may come to para 11, Lordship, of the judgment. That is page 5 of the judgment.
Yes.
Lordship, that the apex court considered the meaning of reasonable grounds in the decision reported in 2007 7 SCC 798 Union of India versus Shiv Shankar Kesri and held that the expression reasonable grounds means something more than the prima facie grounds. It connotes substantial probable causes for believing that the accused is not guilty of the offence charged, and this reasonable belief contemplated in turn points to existence of such facts and circumstances as are sufficient in themselves to justify recording of the satisfaction that the accused is not guilty of the offence charged. Now, Lordship, para 12. It was further held that the court, while considering the application for bail with reference to section 37 of the Act, is not called upon to record a finding of the that the accused is not guilty. It is for a limited purpose, essentially confined to the question of releasing the accused on bail, that the court is called upon to see if there are reasonable grounds for believing that the accused is not guilty and records its satisfaction that the existence of such grounds. But the court has not to consider the matter as if it is pronouncing a judgment or acquittal and recording a finding of not guilty. Now, Lordship, para 13, most of the judgments are stated in that para. Now, Lordship, para 14. On a plain reading of section 37(1) subsection B and 37(1)B Roman 2 of the NDPS Act, within the ambit of the settled law, it has to be understood that the two ingredients shall be read conjunctively and not disjunctively. Therefore, satisfaction of both the conditions are sine qua non for granting bail to the accused who alleged to have been committed the offence under section 19 or section 24 or 27A, and also the offences involving commercial quantity as provided under section 37(1)B of the NDPS Act. Unless section 37 is not amended by the legislator in the cases specifically referred under section 37(1)B of the NDPS Act, the court could not grant bail without recording the satisfaction of the above ingredients. Now, para 15, Lordship. It is well settled by the Honorable Supreme Court in Catena of decisions that subsequent bail application is maintainable only when there is a change of circumstance in favor of the accused. A reference in this context can be made to a decision in state of Tamil Nadu versus S.A. Raja, reported in 2005 8 SCC 380. Here, in this case, admittedly and except the length of detention, no change of circumstances has been taken in place in favor of the accused, and learned additional PP has rightly pointed out at the time of hearing. Lordship, para 16. In the case of NCB versus Mohit Agarwal, reported in 2022 0 Supreme SC, page 1619, a 3 judges bench of the Honorable Supreme Court has held that the length of period of his custody or the fact that the charge sheet has been filed and the trial has commenced are by themselves and not consideration that can be treated as persuasive ground for granting relief to the accused under section 37 of the NDPS Act. Para 17. That being so, the length of detention to the considered opinion of this court can neither be a change of circumstance in the favor of the accused, nor be it is a ground of releasing the accused on bail. Admittedly, the quantity of contraband recovered from the possession of the accused is of commercial quantity, and as such, the embargo under section 37 of the NDPS Act will definitely come into play here in this case. Moreover, from the materials placed on record and also from the case record as well as from the submission of the learned counsel for the accused, this court is unable to derive its satisfaction that the accused petitioner is not guilty of the offence and he will not commit similar offence, and thereby his bail was rejected. This is the bail order of the co-accused person. Now, Lordship, coming to the long incarceration, that Kalyan Chandra Sarkar judgment is there. It is a 3-judge judgment where it is clearly said that long detention is not a ground for grant of bail and it is not violative of Article 21 of the Constitution.
Yes.
Now, Lordship, may come to section 479 of BNSS.
Yes.
Maximum period for which under trial prisoner can be detained. 479(1), where a person has, during the period of investigation, inquiry, or trial, under this Sanhita of an offense under any law, not being an offense for which the punishment of death or life imprisonment has been specified as one of the punishments under that law, undergo detention for a period extending up to one half of the maximum period of imprisonment specified for that offense under that law, he shall be released by the court on that bail. Provided that whether such person is a first-time offender, he shall be released on bond by the court if he has undergone detention for the period extending up to 1/3 of the maximum period of imprisonment specified for such offense under that law. Lordship, in NDPS cases, the maximum imprisonment is 20 years. And if we go by this section, then half of the punishment is 10 years. And he's not completed that 10 years of detention, Lordship. And the trial is going on and it is currently at the investigation stage. So 479 and also 436A, it is of CRPC. It is applicable in NDPS cases. Lordship, regarding the ground of arrest, we will submit some judgments on that, Lordship. Our senior has just instructed me.
My understanding is in two grounds. One, non-communication, second is non-compliance of section 50. And ground of arrest was not. But if two judgments, normally two judgments are cited by for this ground. One is public because the another is Bihantwa. But if both these judgments are relating to, not relating to NDPS sector. And Lordship recently, Lordship probably knows that recently Supreme Court is in another case, this is also not related to NDPS. Supreme Court says that judgment has been reserved by observing that whether in case of arrest where accused means arrested in red-handed, whether the ground of arrest of this is made to be compulsory law. So Lordship, allow me some time, and I want to place some judgment along with my written submission. So fix on Friday, by Friday 5, giving a copy to my land appointment also. Because this point has to be decided by your Lordship. And another Lordship, here the accused was arrested in '22, and all these judgments are subsequent to his arrest. It is also whether this judgment will be applicable in case of this case also. This is also be decided by your Lordship.
In that case, your matter may be to Paragon possible. What to say, we are not in a position to give you any date. In fact, all the fixed matters are more than 25 to 30 matters a day in each every day, up till most probably 13th to there are matters. I don't know, but if it is because there are issues, some issues were popped up, in fact.
Yes, sir.
Regarding the grounds of arrest. Mr. Mandan is also appearing most probably on 2nd. There are
made before court number 24. This court has also observed that whether these judgments are applicable in case of NDPS or not. That is to be decided by a Lordship, because till date nothing has been decided by any of the court.
Now, one thing I would like to point out, what my learned friend is saying. I have argued the matter on the ground which My learned friend has not said anything on that. My case was very simple, Your Lordship. In a case where there is a violation of Article 22(1), let us forget the first part with regard to long inculcation. But with regard to 22(1), I have stated that when there is a violation of Article 21 and 22, what the court will look into. They look into whether that has been followed or not, the fundamental rights have been violated or not. At least one argument from my learned friend saying that the fundamental rights have not been violated in this case. That submissions are making, just giving 10 judgment. I also can come up with 100 judgments, Your Lordship. That is not the fact. The fact is that what submissions I have made, that this court has, what is the power of this court? That I have stated, Your Lordship. There were 2 judgments I have given. The Supreme Court has said, what is the power of the court when there is a fundamental right violation? When there is a fundamental right violation, this court has only one issue, that bail should be granted. You don't have to look into the facts and circumstances of the case. Both the cases have, both are Supreme Court judgments. On the basis of that, I said, we are not concerned who has red-handed this, that I have already stated. Now my learned friend has to submit that yes, this 22(1) violation is not done because we have submitted these are the grounds. That would have been his first submissions. Second submission is with regard to long inculcation part. That is a separate issue.
He is raising another point. He is raising that in those judgments which were cited in the precursor, whatever, there was most probably NDPS matters were not dealt with.
That is what
that's what he is saying. So he wants to cite some of the judgment wherein the Supreme Court had, otherwise I don't know what is the
I'm
position.
also not sure, but I understand what I understand from what my learned friend should ask himself whether there is a violation of Article 21 or the fundamental rights. Does it matter it is a NDPS case or it is a UPA or a PMLA case? That I think he should ask himself. He is a senior person, he knows it. Just making submissions will not do. I know, Your Lordship, so many senior counsels sitting here. Just ask anyone, Your Lordship, when there's a violation of fundamental right, does it matter it is a UPA, a PMLA or a NDPS matter? That is why it's unnecessarily taking the matters.
My reply will be yes, because it is NDPS case and scheme of the act is different, Lordship.
No, I'm not on the act, I'm saying constitution.
Yes, Lordship, because the Lordship has to go by the act also. What offense they have been committed. Because Supreme Court has taken different view in case of NDPS. In many judgments are there.
Kim, can you be tomorrow up to any other people interest in fixing? Pardon? Second, 35 is done. 35 matters are done. Date is a very concern for us. In fact,
let him submit a judgment. I am not objecting on that.
Ownership, if it is transformed to, then under it can be completed with one. Second to go to including all this. You'll be able to furnish those judgment by tomorrow, or because from second onwards, I don't think it will be possible on our part. On first tomorrow also one ownership matter is there.
I'll submit my written submission tomorrow.
No, with the judgment you want to cite it.
My argument along with the judgment.
But we cannot give you any time, Mr. Mannan. We are not in a position to give you any.
The judgment, close the case, keep it as Your Lordship reserved, and let him give whatever judgment.
Because for hearing submission, we don't have any space because there are 35, 40 numbers. All the matters have been fixed.
Only just one copy of that maybe. That's it. The copy of submissions, what he means.
Definitely, when I will submit to Your Lordship, definitely I'll give a copy to my learned friend.
That's all, Your Lordship. I am not going to argue on that.
So can it be fixed for closed, or it will be fixed on tomorrow?
Keep it as a reason.
Give me the liberty to submit whatever I want.
Order reserved for it. So we are reserving the order at present.
Today at 2 o'clock.
Today, no, tomorrow.
Tomorrow.
With the liberty to punish the written argument by learned standing counsel Mr. Pai, learned standing counsel and civil Mr. Pai by tomorrow. আমি ডেলিভারি অর্ডার পেন ডেটে কোন দিন লিটারালি যেতিয়া হ'ব তেতিয়া আপনি লিস্টিং কৰাই দিও and delivery order বুলি একো ৰাখা নাই প্লানিং if it is baby then we are দিব পাৰো তেতিয়া নহয় so at present we are reserving the orders আৰু দুই নম্বৰ কথা হৈছে আপোনাৰ he will furnish his written argument by tomorrow that has already been reflected. And post of which justice was done. More also, how are you feeling? Also wrong here. Hearing all these issues probably from the morning also. These are the judgments.
Picture 2, item 2.
I think.
Lordship, in this matter, your lordship has sought
Oh,
instruction.
yes, yes, yes.
Lordship not yet submitted.
Not yet submitted.
No.
So, as per you, we have already completed the
Completed.
statutory one.
Yes, Your Lordship.
60 days.
60 days.
Heard Mr. K. Mira, the learned counsel for the petition. Also heard Mr. D.P. Goswami, the learned additional PP appearing on behalf of said respondent. This is an application under section so and so in connection with so and so. Next point, it is submitted by Mr. Mira that the accused petitioner got arrested in connection with this case on 20/01/2025. And as on today, he has completed his statutory period in statutory period of 60 days, but till that the IO failed to furnish the charge sheet. In that context, next one, in that context, Mr. Goswami made an inquiry as to in regards to submission of charge sheet, furnishing of charge sheet by the IO, and and as per instructions, the charge sheet is not yet prepared and filed in connection with this case. Next point. So without going detail into the merit of the case, only considering the length of detention, I find it a fit case to extend the privilege of bail to the present accused petitioner. It's an intermediate quantity.
Intermediate one. 21B.
21B. But you are on custody since 2001. 2002, 2003, 20. Already 3 months left.
Yes, sir.
3 months.
Almost 3 months left. Allow for you. But to whose satisfaction it has to be?
Yes, Your Lordship.
It has to
Special
be.
Judge Kachar.
Pardon?
Kachar, Your Lordship.
Kachar
Yes,
Seizure. Learned special judge Kachar Seizure. Not yet charge sheet.
Okay.
16.
Mr. Kyle is also here, I think he left.
In the first half, I was informed that they will file a written objection.
Acha. Just will get the information for the time being.
18.
That kindly this matter may be taken after 2 weeks.
After 2 weeks.
After 2 weeks.
7/18. At the request made by the government council for the petitioner, that the matter be listed after 2 weeks. as on a date to be fixed by the registry.
Oh, bless.
19.
In 19 also, these issues are there.
That issue is there one, but here your lordship, basically the co-accused have already been granted bail by the trial court itself, but that was on a health ground, but he was given. Here your lordship, there were no allegations against me. Only later on, there was, apart from that, I'm just pointing it out from the facts itself. Your lordship will find the
All
FIR
matters are already been disposed of by some coordinate benches, I think, no?
in this case.
The out of same FIR.
No, head to
By
decide
Justice Nandi, 4 or 5 matters by Justice Nandi and 1 matter by Justice Pound, and other matters are all matters by Justice Nandi. It will be listed list after 1 week corridor date will be fixed by the registry court, because we don't have any alternative. Otherwise, if you insist on date, then it will be
No, I'm
go
not
up to
insisting it.
then it will go up to either 17th or 19th.
No, I'm not insisting on date. I'm
After
just
1 week,
no, lordship.
as a date to be fixed by the registry.
1 week discipline.
20.
আজি কলম বেলেগ কৰা নাই বিচব একেলগে
20 and 25 may be taken up together.
Just a
After
second.
rising up
20 and
25.
20 you are appearing both in 20 and
Yes.
25. Both the
Both.
matters.
Lordship will take up 25 first, Lordship. That is a regular bail application.
25 to
This case, Lordship, the petitioner is in custody since 13/3/25, Lordship. As of date, 49 days, Lordship. Lordship has, on the earlier occasion, Lordship has already perused the case diary in this case. And
case diary was perused.
yes, and then after that, Lordship has granted interim bail to the petitioners in item number 20 to appear. That is, Lordship will remember at Gaubura's case, Lordship of means assaulting police personnel, Lordship, when they went to arrest some accused persons. I'm just coming to the FIR, Lordship.
His petition was earlier rejected, na?
No,
His
no.
petition was
No,
earlier
no.
rejected.
His petition was not rejected. Lordship found that from his statement that he was taken up in custody, then he flew away from the police custody, then Lordship said that let him remain for some more days, and Lordship called for the up-to-date case diary. Order would be there, Lordship.
That is in item number 20.
20. He is in custody, Lordship.
25 to custody.
No, 25 is in custody, Lordship. 20 is anticipatory bail. Same is in respect
So
of
he was granted with interim.
which one, Lordship? Is
In
2020.
20.
20. All the petitioners were granted interim and were asked to appear before the IO, Lordship.
So here the Gaubra is not there.
No, Gaubura's, on that day, Lordship has rejected Gaubura's petition, Lordship. Gaubura's son is there, I think, Lordship, there. That's petitioner number 1, Ainal Hoff. Yes, I'll read out.
Ainal was given the pre-arrest bail.
Lordship said that let all of them appear, so whatever statements may be recorded.
So here the Gaubra is not here.
No.
Gaubra is already in custody.
No. He came for anticipatory bail, Lordship. On that day, when the case diary came, this bail applications, Lordship granted interim bail, and his bail application was rejected, Lordship.
Oh, so it was rejected.
Lordship, just coming to the FIR, Lordship.
In which number we are saying now?
25.
20. Okay.
Same FIR, Lordship. So
yes, anyway, so he is in custody for 49 days.
49 days, Lordship. And
then?
the offense, Lordship,
One is 61(2)(b), 121, 1 and 2, and 132. The other two, Lordship, the punishment is up to 61 is 6 months and other is 2 years. 121(1) may extend to 5 years and 121(2) may extend to 10 years, Lordship. Now 121(2) will come, Lordship, only if they have sustained grievous injury, Lordship. Lordship, I'd like to take Lordship to the 121 of BNS.
BNS. BN. 121, 2.
121, 1 is, Lordship, 1 is also there. One says whoever voluntarily causes hurt to any person being a public servant in discharge of his duty as public servant or with the intent to prevent or deter that person or any other public servant from discharging his duty as such the public servant or in consequence of anything done or attempted to be done by the person in the lawful discharge of his duty as such public servant shall be punished with the imprisonment of either description which may extend to 5 years or fine or with both. Then 121(2), Lordship. Here the punishment is voluntarily causing grievous hurt. So there must be injury, Lordship, and that must be grievous, Lordship, in this 121(2), where there is 10 years. So otherwise it will be a 60 days offense, Lordship. So that is my submission, Lordship. He has already been in 49 days. So considering his length of detention, Lordship, may consider his bail application, Lordship. And in respect of the anticipatory bail application, Lordship, all the pursuant to this interim order, Lordship, they have appeared before the IO, Lordship. Lordship will see from the case diary what is there.
Yes.
My lord, we have received the case diary, my lord, but the medical report not received, my lord. So may I pretend that the matter come up next week, my lord?
In the meantime,
because the allegations are very serious, my lord. They have attacked the police personnel, my lord, who, my lord, went to apprehend the accused person, my lord, in connection with some other case, my lord. Then on the, my lord, behest of the, my lord, Gaobuda, my lord, this accused person, my lord, including the petitioner in item number 20 and 25, my lord. They all robbed the, my lord, police personnel, my lord. They totally demolished the, my lord, vehicle, my lord, and assaulted the police personnel, my lord. Now, my lord, the grievous injury is grievous or simple, my lord, that will reflect from the, my lord, medical report, my lord. So my humble submission, my lord, we'll fix it next week, my lord. With the injury report.
Lordship, in case of item number 25, Lordship, and consider, Lordship, he is already in 49 days.
See, because previous, this thing is not with us, I think medical report.
That will be required, ma'am.
Whether there will be possible, Lordship, in next week. Then
next week, my lord, 6 or 7 months, we'll retain the case there, but call for a medical report.
Only call for the medical.
Yes.
For my instruction, Lordship, no such medical injury was there, Lordship.
But we have also seen in sometimes in the TV and all, the people come in an aggressive manner and attack the police officers.
The police officer, my lord, how can they will maintain the law and order duty?
Giving date is now very problematic because we don't have any dates. We're going to within the case diary, but that will not serve the purpose because anyway case has to be there. Date night full. From 7 and 6. At this 6. See, for giving a date, we have to consult them immediately because we don't have any dates in fact. All fixed matters are above 20, 25, 30 matters a day in every day. Today also some of the matters will be left over only. It will not reach. Anyway, hard correction. 20 or 25 or more or less একে order হ'ব 20 হৈছে AB ইমান লিখিব নালাগে 20 AB heard Mr. M. Ahmed, the learned counsel for the petition, and also heard Mr. R.J. Burwa, the learned edition appearing on behalf of state respondent. বাকি লিখিব নালাগে CD receipt. However, it is submitted by Mr. Burwa that the injury reports are not available in the case diary, and hence he submitted that retaining the case diary, the injury report may be called for from the IO. He will intimate the IO in that regard personally. Considering his submission, let the matter be listed on 6/5/2025. And till next date of listing, the interim granted to the petitioners be extended. 25 simple has so and so. A case submission, CD not available. List 6/5. Both the matters. Okay.
The 21 way receive instruction matter, charge is submitted in this case.
Charge it already submitted. Yes, Mr. Ali, you asked your petitioner to file a regular bail application before the learned trial court bill. That may be considered. Otherwise, how many days you are in custody?
85 days.
85
days.
Oh, quite a considerable period.
But the charge is submitted matter in the month of March itself.
Oh, then
I think
he filed his petition on 25/3, or not on 25/3. Prior to that, I think 10/3 first order was there.
Yes.
On 10th matter, the first order pardons, my lord. Then on that day, matter charge is submitted.
Oh. Because of it is a POXO matter, so that's why.
That is no POXO 4 matter. POXO 4 also added.
POXO 4 is added. Heard MS Ali, Mr. S. Mohammed S. Ali, Mr. S. M. Sorry, Mr. M.
MD MS Ali.
Mr. M. S. Ali, the learned counsel for the petition, and also heard Mr. R.J. Burwa, the learned edition PP, appearing on behalf of state respondent, and MS M. K. Brown, the learned amicus, appeared on behalf of the respondent number 2. Case was fixed for case diary, but it is submitted by Mr. Burwa, the learned edition PP. That case has already been charge sheeted. Yes, by charge sheet number.
The charge sheet number 46/2025, dated 10/3/2025.
Baki okay. Your matter we are disposing with a direction to appear before the day.
Hello.
22.
Your matter is also what kind of matter?
NDPS, commercial, but in the other than ground of arrest, we have some more ground is regarding long incarceration.
How many? What is the period of incarceration?
2 years, 6 months, and 4 witnesses have been examined out of 11 witnesses. And if my trial goes in this promptitude, it may take 5 more years, Lordship. This 4 in 2.5 years.
So your argument will be exclusively on the incarceration, or you want to argue in the other matters also? Because other we are adjourning. Because 2 and 3 matters have already been.
I would like to argue on long incarceration.
No, we are not on that. Long incarceration is there.
Yes, Lordship.
And apart from that, you are taking also the ground of arrest.
Lordship.
So in morning, we are listening on the ground of arrest only. And the 2-3 matters have already been, order has been reserved. So we are not in a position to reserve further for more orders. That's what. So we will give a date in that case.
Let me argue in the long.
Arguing is question is not, we are, if you are taking the the ground of arrest,
Yes.
then we are adjourning it. That's what.
This is my second ground. First ground is long incarceration, Lordship.
What to say?
Lordship, search framed on 10/3/23 and PW1 examined on 2/4/24. 2 is 23/7/24 and PW3 is 3/9 and 4 is also 10, Lordship, 10/24.
10?
4/24, 10 or something, Lordship. So
Last
last PW4 was examined on
20?
24, it was not reflected in the date was not
Yes.
reflected. So
When?
out of 11, 4 is examined, Lordship. So yet another 7. which
When,
we have to
Mr. Ram?
examine.
When your last examine?
Last copy is not with me. Actually, I have submitted only 3 PW3.
Last date was
Fourth one-
7/4/25. So wait for 7/4/25. We have any witnesses are examined or not, that is not reflected in the SCR, Lordship.
But whatever, till now,
Only
four.
Four is
is
examined.
This your argument is if we stick only the incarceration, then we are going to hard, otherwise not. First part, second part is okay, but we are not going to hear it. If your argument is only confined to the long incarceration, matter may be hard, otherwise not. Because since morning, we are hearing on the long incarceration, grounds of arrest.
I will submit my argument in writing in the grounds of arrest, and regarding the long incarceration, I will really argue. So if you can reserve, it's okay, not an issue.
What you are saying?
কিছু reason নাই যদি হেতু ফিল লোৱা তেতিয়াহলে আপোনাক হেৰি কৰিব ডেটটা দিব from the morning time what she has done many arguments.
Okay, Lordship, kindly give me a time, a date, but a little bit early.
Pardon?
He is seeking early dates.
No early date. Just, we can show you our list. Up to 13th and 14th. Many matters are there up to 2020. Early date you cannot. We are ready to hear you only on incarceration if you want to submit. You have some ground, you can argue.
Yes, I have.
And it's okay, you can argue it. Only we are restricted to grounds of, incarceration.
Lordship, give me a date.
If you want to argue on with the council.
Yes.
Okay. No, otherwise I must say your petitioner is behind the bar since 2 years. 2 years, 6 months. So that may be one of the long incarceration, maybe.
Yeah.
Maybe, I don't know what is there in the
Yes,
case.
Lordship.
Because there may be some implications, there may be some other ways also.
Lordship.
At this stage, we cannot say, but long incarceration may be one of the ground for you. If you want to place both the grounds, then we'll fix a date. That too, it will be up to 14, 15, it will be on 14th. 14/5. By that time, some of the orders will be there. We 4 orders we have reserved.
Yes.
And on second, yes, tomorrow and the second also, we are hearing on that matter only.
But this is a ground, so very strong ground also for me. And other than long incarceration, it's
Okay.
also strong for me because I have
Yes.
2 and 6 months. In 6 months.
Then we
I will
will
support-
fix your case on 14th, okay? Because
14th,
3, 4 matters have
14th.
already been reserved. That's why we are not going to reserve further cases. That's what I'm saying. On the same ground. 14th will be do. 14th will do.
Okay.
1/4.
Yeah.
You can submit your written examination as well as by that time some orders may be there also.
Yes. Yes.
More or less on the same line.
Yes, Lordship.
There may be some argument on the long incarceration as well as on the grounds of arrest.
Lordship.
So grounds of arrest we are hearing
Yeah.
since morning. So they result there may be some order.
Lordship.
Either this way or that way. I don't know. Okay. Then. So we are fixing it on 14/5. You
Okay.
can on 14/5, if you're ready with the written argument, you can submit.
Sure. Obliged.
23.
Madam, that 23 Lordship can fix it 14 also because I have also taken long incarceration coupled with the violations. So I will not take much Lordship's time. I'll also submit along with that brother.
On 14th?
14th, my lord.
Okay. 14/5. By that time, if 2, 3 judgments I can pass by that time, yeah, up to 14th. Then more or less it may be this way or that way, whatever, but the order may be there. only.
Long incarceration, he has, my lord, he has spent 2 years, 3 months as of today. And
He
so-
has 2 years, 6 months.
Yes, ma'am. Mine only, my lord, 3 exam in till date. And
Out
next,
of- out
out
of-
of 8, my lord.
out
And
of
next
8.
date is fixed by trial court on 36, my lord.
36.
Yes, my lord. It was last posted on 3/4/2025.
That
Then
is
na-
almost more than
And
2 months.
Yes,
2
my lord.
months.
On 14th, my lord.
Definitely, if the case goes on that pace, then definitely it will take
Much time, my lord,
much
in
time.
culmination of the job. I'm DP of that. On 14th, my lord.
Okay. Yes.
24.
May I please, Lord?
Yes, here, now how many?
Learned friend submit. I'm appearing on behalf of the informant lordship.
Yes,
I would like to.
your name is here.
Written objection lordship.
You
I
want
did
to
that-
file?
Yes, a week's time, because this is the same person, same victim twice. Because earlier also he did, and he was on bail, and again he committed sin, and she was pregnant, she delivered a baby, so I want.
With the same victim or?
With the same victim lordship, I want to bring on in records, and also the scan copy of that case record will be required lordship. So
Scan
same
copy,
victim, same
scan copy of which, just tell us. One scan copy we have already received. For
Yes.
current, but for this one, I think, this is the scan copy record of. 31124 report to number. Report to number.
Case number 519.
Oh, it is not charge sheeted case.
Cheated.
Then
Yes,
court
Session
case
special
number.
case, session special case number 31124.
Session special case number 31124. That we have received, and you want to call for which record otherwise?
Another one lordship, which was that case, I'll bring in my written objection, those case details as well. lordship.
No. If you
Records
want
will be
to
called.
call for the record, then you have to provide us the
Case,
call.
case number.
Case number,
lordship,
yes.
That sessions case number, I'll get it, because support person will provide me with the sessions case number, because CWC has appointed a support person in this case, and support person will provide me with all the details of the earlier case.
Your
Sessions case.
petitioner is behind the person, oh, sorry, it is a charge sheeted one.
Substituted.
In,
And then the bar since
And in fact, the family is also
26 days.
troubling the victim's family lordship, because to withdraw the case. And in the second time, earlier also she was pregnant, she was 3 months pregnant, and there was MTP lordship. And now she delivered, she was in CCI, she delivered a child, and thereafter child, the newborn also is in the CCI.
And in this case, lordship, charge frame on 13 to 25. There are 13 PWs are there also.
whatever, we'll see the status. Otherwise, for considering her submission, she is going to file a written objection. That may be considered otherwise.
I won't take much time, only a week's time will be.
Heard Mr.
S.H. Rahman.
S.H. Rahman, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent, and M.S.D. Ghosh, the learned counsel for the appearing on behalf of the respondent number 2. It is submitted by M.S. Ghosh that she needs 1 week time to file his written objection in that regard, and she also insisted you are going to provide the case number now.
Yes, only. I just.
We will just
Yes.
insisted to call for the case record of so and so, wherein in which case also the present petitioner committed the same offense with the same victim. Record of so and so we also be called for an acadium. In the meantime, the learned counsel for the respondent number 2 will file her written objection. List accordingly, 1 week to we cannot give. It will be either 15, 16, right? 16th of May. Just we are keeping this one gap is there. We picking the case number blank. Yes, just okay. Oh. Sure. How old the person is?
Now 16 years.
No, person. Accused person.
32 years.
He's a married man?
Married.
Because after first, when he was released on bail, then again, his wife also conceived, she also delivered a second baby.
Oh, very nice.
Lordship, item 16 year. Lordship.
Item
16 year, Lordship. I have some problem here, Lordship. So I am seeking for fixing a date here, Lordship.
Item number 16. Oh, it was time.
Time being met, answer being met again.
But as per instruction NCB, you are supposed to file the
In
written
morning,
objection.
your Lordship, that is one council of the NCB, I was informed that they will file objection.
Okay, then we'll reflect in the order, in our order. It will file written objection.
It was informed me, your Lordship, but
that today they are going to file.
they have not said that they are going to file one today.
No, no.
But they said that they will file objection.
File করেছেন।
Immediately after your Lordship.
Heard Mr. A.M. Khan, the learned counsel for the petition. However, the standing counsel of NCB has not appeared. However, it is submitted by Mr. Khan that due to some personal inconvenience, he wants an adjournment. Prayer allowed, is the matter accordingly. Now see, you have to take date either 15, 16, otherwise we don't have any date. I mean, we are sorry that we don't have
14,
any.
14 year Lordship then.
14 already, 2 matters are fixed now. Now, just now we have fixed 2 matters.
15?
15, okay. 15-5 freedom. In the meantime, the 15-5, in the meantime, the state and NCB, respondent NCB may file the written objection if any. Okay.
26.
Right, Lord.
Yes.
Lordship, the application of 483, Lordship. So allegation is a theft, Lordship. So Lordship, the article are very simple article, Lordship. So the petitioner is the employee of the High Court, Lordship, the contractual basis as a sweeper, Lordship. So sweeper, Lordship. And
Sweeper.
article. Yes, Lordship, yeah, High Court, Lordship.
Yes,
Oh.
there are some articles from the ground floor, Lordship, Dettol, phenyl, baking the door of the door, Lordship. I mean, 47 days in custody today.
Yes, 48 days, Lordship, behind the bar, Lordship.
Who name? He named that?
Vivek Bhaskar, Lordship.
You Vivek Bhaskar. Motu name কি আছে Manoj?
22 years old,
Manoj কি
Lordship.
নাম?
Contractual basis, Lordship.
He was in under contractual basis.
Yes, Lordship. It's a Subho International Social Service Organization conducted by this organization.
Sulabh Karmachari.
Yes, Lordship. And
items were recovered from his person.
Yes, Lordship. Page 14, Lordship.
What are the items? Dettol, phenyl, Harpic.
Phenyl, Dettol, Harpic.
And bleaching powder, 1 packet, 0.5 kilo. Very major amount, Lordship. Quantity, Lordship.
You have received the
Harpic-
case day also.
Yes, and yeah, that's all.
Okay. Heard Mr.
Arsidas.
Kiman number here, Amma?
26.
Heard Mr. Arsidas, the learned counsel for the petition. Also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of the respondent. So this is an application, the section so and so in connection with so and so CD receipt. That is the same. He is in custody since
48 days, Lordship.
48 days. It is submitted by Mr. Das that the accused petitioner is in custody for last 48 days, and considering his length of detention, he may be enlarged on bail. Next paragraph, Mr. Goswami, the learned additional PP, however, submitted that all the materials, the theft goods are already been recovered from the possession of the accused petitioner, and there are sufficient incriminating materials against him. Next paragraph. Considering the submission made by learned counsel for both sides without going into detail of the merit of the case, I find that further custody interrogation may not be requested and supported. To whose satisfaction it has to?
CGM.
CGM Kamurphat. CGM Kamurphat. Okay, well, that.
27.
May it please your lordship, postpone matter, lordship, no ground of arrest was communicated to the petitioner, lordship. which I have reflected in the, which I have given marking in the LCR, Lordship. It is there in the LCR section
Just a
47.
second, POXO is there.
Service is awaited, Lordship.
Lordship, I have placed two judgments of your Lordship, similar footing, Lordship, exactly similar footing. There are also services awaited, Lordship, of your Lordship order. There are also services awaited, Lordship.
Services awaited.
Yes, Lordship. Both the cases, Lordship. Recent judgment, Lordship.
Okay. Heard Mr. P. Bodoli, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned addition PP appearing on behalf of said respondent. This is an application section so and so in connection with so and so. Where you have annexed your the
No, Lordship, it is
notices.
I have taken the ground, Lordship. It is in the LCR, Lordship. Notices are in the.
You have
LCR.
received the LCR.
Yes, Lordship. I flag
It is a case of charge sheeted one.
Lordship. I flag
Already search frameworks.
I flag marked.
Your petitioner's name is Mirad Ali.
No, Lordship, Saiful Islam, Lordship. His father name is Mirad Ali.
Saiful Islam.
Saiful Islam. Yeah, charge framed on 5325.
So was the girl is of how many years age?
Petitioner 20 years, Lordship.
Date of birth is 20 to 120.
Girl.
So very minor one, 4 and 5 years between, 4 to 6 years in between. Guys.
And so they submitted by Mr. Bodway that the accused as well as his relatives were not communicated with the grounds of arrest while issuing notice under section 47/48 of the BNSS. Further, there is no grounds of arrest mentioned in the arrest memo, which was furnished to the accused petitioner at the time of his arrest. Which violates the so and so. In that context, Mr. Goswami, the learned additional PP, submitted that the service is still awaited for the respondent number 2, and wherein the respondent number 2 and bail order may be passed in presence of the respondent number 2. Respondent number 2, full stop. Accordingly, he raised objection, and further he submitted that case has already been charged. Charge has already been framed against the present accused petitioner, and also considering the nature of allegation as well as statement made by the victim, it is not a case for bail. Grounds of arrest. Okay, Bodal will pass the order.
Oblige, your Lordship.
29 and 30.
Order DIS, same no FIR
on 23rd.
Also very voluminous or what?
Lordship. I received today, Lordship, at 11 AM, Lordship. So I informed my senior that I will be at least accommodate at least 2 days time to go through it. Day after tomorrow, Lordship.
No, I have another submission. Which he informed me at 1:30. And with responsibility as a senior counsel, I say, most probably my learned
Yes.
colleague will also agree.
Yes.
Because here is the question. It's a retributory process of investigation is going on. I will show after he sublet, since the case diary has come, there are three, if a lordship look at your lordship's order on
No, no,
20
first we are going to hear otherwise whether you are going to submit anything today or you want some time. In that case, better to hear the matter as a whole.
Tomorrow, 2 o'clock, your lordship has fixed my item
Yes,
for
yes.
Arunachal.
Yes, yes, from
So I will
Arunachal.
complete this part of the argument because election case, my argument will hardly take 15-20 minutes. At 2 o'clock, if it fixes, he can file his, your lordship will look at your lordship's order on 23rd of April. 23rd of April, there are 3 parts in it. Call for the case diary. So case diary has come. Only his problem is he has no time to go through it. Let him go through it today. And the second part was they were given an opportunity to file an affidavit also if they are so advised. That has not come. At least he also gets it clear 24 hours time because it's a completely question of a violation of a fundamental right. Your lordship is because I will, moment he files it, I will expose everything, how it becomes a retaliatory kind of a prosecution that is going on. And so let him bring it and he will submit. I will also make myself at 2 o'clock because election case will hardly take 15-20 minutes. That your lordship is fixed at 2 o'clock tomorrow.
Can it be completed within 10-15 minutes? But
I'm on
no, no, you were there, I know. You and Mr. Majumdar is there.
I'm on me. Because if it, at 2 o'clock, if this case is taken up, 2:30 I can start and I assure your lordship, by 3 o'clock my argument will be over.
In which matter?
In the
Election matter.
Election. And if his reply argument is there of Mr.
Majumdar.
Or Majumdar, he can get 1 more hour. That is, so at least 2 o'clock, at least your lordship can proceed with. Because there are
Yes,
2 young gentlemen, it's a retributory process of investigation going on with responsibility. This is my submission. And hopefully he also knows about it.
I will show the
Yes, let him
contrary
show. I am
submission
not.
to that, Lordship. What is the deep-rooted conspiracy they have access to get that public money and that system has been spoiled? How, Lordship? Everything will be clear. That's it. That is it.
So if he knows about
Tomorrow will be
Tomorrow,
about
day after tomorrow, Lordship. Friday.
after tomorrow again, same problem is there, I think.
At 2.
At 2 o'clock.
Day after tomorrow.
I know your lordship has been.
Flooded with, yes, there
Yes,
are so many matters.
I have seen it, my lord.
At 2 koile baki all other matters will maybe adjourned. For Friday at 2 যদি করে দিই, সেটা other matters will get adjourned. কি করবো? I don't know. ইমানাও চিন্তা করে সেটা নোৱাৰি। Up to 1 but 2 মোটামুটি সেই লগে দিবেন। Fix at 2 করে দিব ঠিক আছে। Our Mr. K.B. Pathak, the learned senior counsel, assisted by Mr. F.K. Ahmed, counsel for the petition. Also heard Mr. P.P. Dutta, the learned special public prosecutor, CM Vigilance 6 for the state respondent. CD received, but it is submitted by Mr. Doctor that he needs some more time to pay his decision as it is as the CD is a very voluminous one. Considering the submission made by Mr. Doctor, let the matter be listed on second, that is second, 2/5/2025 at 2 p.m. Okay, well.
Okay.
Person is in custody from 18/3/2025.
Since when?
18/3/2025.
If you want to make submission in that case here before this court, then we have to call for the case record. Otherwise, we don't have any alternative. Or we may make a order directing you to appear before the London Trial Court Bureau with a regular
No, it
application
has
for
not
bail.
been committed. It will unnecessarily delay it. But I don't think
In that case,
Your
we
lordship
can
direct
call
it-
for case record.
Yes.
Case record scan copy.
Scan copy of the case record.
Heard Mr. B.D. Pond, the learned senior advocate, assisted by P. Soren, MSP Soren, the counsel for the petition, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Goswami. That case has already been charge sheeted, right? CS number, yes.
96/25, dated 31/3/25.
In that context, Mr. Kwon, the learned senior advocate, made submission that the matter, the case record, scan copy of the case record may be, scan copy of the case record along with the CD may be called for.
From the court of the Honorable Chief Judicial Magistrate, Kamrup Metro at Guwahati.
Report of Honorable Swans, Kamrup Metro at Guwahati. Yes, but you are not there for news in morning, I think, because we don't have any space to list the matter. Till 13, 14, all are busy. Till how can I say 25, 30 matters are fixed on every day, in fact. Fixed matters are there, apart from that, the other matters will come. Will it be okay for you 16?
16th of May.
16th of May, if it is okay, then we can fix
Yes,
it on 16th.
14 how many?
No, I don't know, you see. Somehow can be 14 of May.
Yes. Oblige. Nowadays, actually, because of the outstation cases, I have to manage my calendar. Otherwise, it's difficult. Oblige, you know.
Oh.
32.
Yes, 32.
Yes. Lordship, the arrest bail petition.
Yes.
Lordship, kindly have a look at the Azahar at page 10.
Page 10.
Lordship, kindly come
Yes.
to page 12. May I read it? I have the honor to inform you that as informed by Sri Amit Singh, OC Silchar PS by Silchar PS DDNT number such and such, quoted under reference at 11:50 AM today, that is on 31/7/2024, that some miscreant are making plastic vials of suspected heroin at Silchar, Kalibali Chor, at the house of Minara Begum. Accordingly, after receipt of the such information, OC Silchar PS has authorized me to leave for the said place and conduct search at the said house of Minara Begum. Accordingly, GDNT was made in Silchar PS by GDNT number such and such. The police party headed by me along with below mentioned staff deputed by OC Silchar PS have left for the said place along with digital weighing machine and other equipments by the government vehicle bearing number such and such, driven by such and such, towards the house of Minara Begum, wife of Manik Miao Police Kalibari Chowk. Name of the such staff such and such. Before reaching the house, the following two persons from the neighborhood of namely Pathauddin Lashkar and Akram Khan explained the purpose of search and requested them to witness the search, and they agreed. They are Pathauddin, Akram Khan. We reached the house of Minara Begum, wife of Manik Miao of village Kalibari Chor, Silchar. We have found her not available at the said place. However, on arrival at the said place, three persons, namely Rakim Lashkar, Abul Kasim, Amir Hussain, were found. Smuggling of suspected heroin. Accordingly, I have served one notice each of the apprehended persons. I am not these three, Lordship. These three persons was apprehended at the spot. It is in the house of the Minara Begum. Minara Begum was not present at the house. What happened, Lordship? Then your Lordship kindly come to page 13.
Yes.
Mary. The recovered articles are duly seized by me in presence of witnesses after observing all the formalities of the NDPS Act. Further, on spot interrogation of the apprehended person, they have revealed that one person, namely Shaheen Khan, son of Babul Khan. This is the allegation against him. On the basis of that, he was under Lordship police behind him. Police submitted charge sheet showing him as absconder. Lordship, there is a no other Lordship in incriminating materials found against him. Only on the basis of this statement, whether he can be convicted, Lordship, and Lordship kindly, in terms of the judgment of the Tufan Singh versus State of Tamil Nadu, Lordship, such a statement, Lordship kindly have a look. Lordship, kindly come to page 70, para 29. Para 29 of the Tufan Singh judgment, page 70, Lordship.
Yes.
Section 25 was originally in the Criminal Procedure Code 1861 and was brought into the Evidence Act 1872. Section 25 states that a confession made to any police officer, whatever his rank, cannot be relied upon against a person accused of any offense. Police officer is not defined in the Evidence Act or in any cognate criminal statute. As to what, therefore, police officer means has been subject matter of a several decision of this court, which will be adverted to later. For the time being, Section 25 is to be viewed in contrast to Section 24, given the situation in India of the use of torture and third-degree measure. Unlike Section 24, any confession made to a police officer cannot be used as evidence against a person accused of an offense. The voluntariness or otherwise of the confession being irrelevant, it is conclusively presumed by the legislature that all such confession made to police officer are tainted with vice of passion. Then your Lordship, kindly come to page 141, para 155. Para 155, page 141. Married.
Para 50.
155. Para. Page 141. Thus, to arrive at the conclusion that a confessional statement made before an officer designated under Section 42 or Section 53 can be the basis to convict a person under the NDPS Act without any non-obstantive clause doing away with Section 25 of the Evidence Act and without any safeguard would be a direct infringement of the constitutional guarantee contained in Article 14, 23 and 21 of the Constitution of India. Next paragraph. The judgment such and such for the reasons stated by us herein after, both these judgment don't state the law correctly and are thus overruled by us. Other judgment that expressly revert to and rely upon this judgment or upon the principle laid down by this judgment also stand overruled for the reason given by us. On the other hand, for the reason given by us in this judgment, the judgment of Nuraga and Nirmal Singh Palwan and Inspector of Custom are correct in law. Then your Lordship kindly come to 158. But next para Lordship, that the officer who are invested with power under Section 53 of the NDPS Act are police officer within the meaning of Section 25 of the Evidence Act. As a result of which any confessional statement made to them would be barred under the provision of Section 25 of the Evidence Act and cannot be taken into account in order to convict an accused under the NDPS Act.
Okay, that is the subtle position of
Lordship.
the basis of the statement of the co-accused one cannot be convicted.
Lordship.
The death
So this is my admission, Lordship, and what purpose would be served if he is arrested, and on the other hand, Lordship.
What purpose would be served, means?
Lordship, if he could not be convicted, then what would purpose will be served? That is my submission. If he is not could not be convicted, then in that event, Lordship,
he should not be arrested.
Lordship, if it is he is not could not be convicted in that event, what purpose will be served? That is my submission.
Subsidy is committed already.
under section 21B and 29 NDPS lordship. And lordship, going through records of a statement made by the arrested accused lordship. As per the instruction of this petitioner lordship, they were engaged of making vials and doing this business for selling contraband drugs lordship. So he is the main keeping on the record lordship. And he's shown as absconder lordship. He is not cooperating with the investigation and several attempts were made. On 5/8/24, his house was searched. 27/8/24, again his house was searched. 17/9/24, always his house was searched lordship. He was still absconding. So my humble submission to lordship, this is not a fit case for granting anticipated by this stage of he is not cooperating with the investigation lordship at this stage. He is the main person behind the whole record lordship. They were making viral in the house of Minara Begum as per the instruction from this petitioner.
So I replied to my learned friend's argument, but nothing was recovered from his house. Lordship, that may consider. So
His
many
house-
occasions his house was searched, nothing was recovered from his house.
No, many occasions his house was not charged. He was searching for, police search for him. It is not the case as submitted by Mr. Goswami that house was searched on various occasions. It's not the case. It's the case that on various occasions house was searched and he was not found. So he could not be apprehended during the investigation. That is his submission.
But even otherwise also, Lordship, nothing incriminating material found
No
against his
incriminating
house pursuant to the statement given by the co-accused Lordship. That is my submission. Lordship, that may be also recorded.
No incriminating materials.
Lordship, from his house pursuant to the statement of the co-accused Lordship. All right.
But if he decided. Heard Mr. Abra Mujumdar, the learned counsel for the petition, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so. I'll give you some part your submission. I'll record later on. I'll pass you. So Ms. Scan copy of the case record has already been received. Where is this? It is submitted by Mr. Mujumdar that the present accused petitioner is innocent and he is no way connected in the earliest offense. From the contents of the FIR itself, it is seen that the present petitioner was searched by police only on the basis of the statement made by the co-accused, which is not at all admissible in the eye of law, and on the basis of and a person cannot be convicted only on the basis of the statement made by the co-accused as laid by the Honorable Apex Court in case of, as ratio laid down by the Honorable Apex Court in case of Tufan Singh versus so and so. Mr. Mujumdar accordingly states on para 25 and 155 of the said judgment, wherein also the Honorable Apex Court had observed that a confession made before police or on the police is not admissible in the eye of law, as well as the statement made by the co-accused under section 67 NDPS Act is also not admissible or cannot be the basis for conviction. So Mr. Mujumdar further submitted that in spite of house search of the present petitioner, no incriminating materials were recovered from the house during the investigation of this case. Otherwise, is there any explanation from your part why you are not cooperating?
Lordship, he is not in any Lordship interim protection, Lordship. He is appeared with the.
No. Why you did not cooperate the IO in the investigation? What reason?
That is the main reason. If he appear before the IO Lordship, he will be arrested, Lordship. No protection is there.
So earlier you filed any for any bail application?
No, Lordship.
Have you received any notice?
No, 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 Lordship.
No, on what basis we are saying that you will be, there is a reason for apprehension. That's why you are not appearing.
Lordship, that's why he was police search
So
him.
it was aware, it was known to you that in the FI itself, there is an allegation against you. It is known to you.
Lordship,
Then why you not cooperating?
Lordship, but he no protection. There is no protection.
That's what I'm saying. There was no protection for him. So he was an apprehension that he may be arrested if he
Lordship,
appears.
Lordship.
My question is that means he was aware of.
Yes, Lordship. Police, police searched him. Police search his house. That's why he is aware.
Okay, the police must have assumed that, but submitted that police made a search on his house, but he could not appear before the IO as there was no interim protection was provided to the present petitioner, and he had the apprehension of being arrested in connection with this case. Next, Mr. Goswami, the learned additional PP submitted in this regard that there are sufficient incriminating materials against the present petitioner in the case diary. Further, he submitted that he is the main kingpin of the entire case, wherein, and under his instructions only, the vials were prepared with the contraband. He further submitted that several house search was made to apprehend the present petitioner, but he was absconding and evading the police arrest, and also did not extend his cooperation during the investigation, for which he had to be shown as an absconder in the case record. That at later one. Later on, I'll decide. I'll go for the case diary.
Okay. All right.
May I please, your Lordship?
Please.
May I please, your Lordship? I'm appearing before this honorable court on behalf of Shri SCKL. So requesting for adjournment of the matter for the day, as I need some time to file the objections.
Lordship, on earlier occasion, they have taken time for filing their objection, Lordship. Also, Lordship. And I am not in interim also, Lordship.
Your case is of commercial quantity?
Yes, Lordship, commercial quantity.
Obviously, the question of interim is not there, but anyway,
But Lordship,
it seems that the case is pending, in fact,
Yes,
since 17/2/2025.
yes, Lordship.
Obviously, on that the prayer of the petitioner, it was adjourned,
Yes.
and again on prayer for the petitioner, it was again adjourned on 21/2 also. So there are two occasions the prayer was
yes, Lordship.
there's a adjourned from your prayer only.
Yes, Lordship.
Heard Mr. K. Thakur, the learned counsel for the petition. And have you received any this case diary is received? No.
I'm not aware.
How can you say case diary by sending it? It's no, it will not please. The responding petition. Can I confirm it? He is also not aware. Instruction. Instruction is on. So what to write? Case diary received or not received? We are not in a position to say. Just take instructions.
Yes.
Just let us know and I'll pass the order now. Okay. Okay, then you are Mr.
P. Hazarika.
P. Hazarika, appearing on behalf of Mr. S.C. Kyle, the learned standing counsel NCP. And it really submitted that he need some more time to file the written objection.
Lordship,
Mr.
I have
Thakur, yes,
I have a
Mr. Thakur
Lordship.
raised object, yes.
Before next date, Lordship, they will file the objection, Lordship, and a copy of the objection may be served to me,
Furnished.
Lordship.
Mr. Thakur submitted in this regard. On the last occasion also, the state NCB, NCB had prayed time to file the written objection. Objection full stop. Next para, considering the submission made by learned counsel for both sides. The petitioner, the state NCB is hereby, respondent NCB is hereby allowed to, and hereby asked to file their written objection on or before next date of listing, and also to furnish a copy to the other side on or before the next date of listing. List accordingly, yes. Anyway, Mr. Thakur, we don't have any date. Our
Yes,
list is
Lordship, I
16,
heard.
17. So many days have already been fixed. At best,
Lordship, after a week, Lordship may be given as in when they will file. We come to know, then we'll make a mention, Lordship.
when without listing a date.
Yes, Lordship. And otherwise, if date will be given, then Lordship is given 14 or 15 May.
Yes, 14, 15,
That
16.
may be fixed, Lordship. Fixed.
Okay.
14 or 15 May, Lordship.
Remove that 14. 16, 16, 5. And you just let us know about the whether case diary is received or not. We are not in position to say anything. Just within a second or within a minute.
Deeply obliged, madam.
Much obliged.
That একটা ব্যাগ একটা রাখি দেবো, CD receive message.
35.
55 matter relates to POXO. On last occasion, service report was awaited.
Services, as per my instruction, services completed, but they have sent to the registry also.
Pardon?
As per instruction of the IO office, service is completed, and they have sent the, it is come to the registry also. So it was not reflected, probably next day it will be reflected in the.
No, service is already completed.
Completed.
And if your service is completed, today date is fixed and we will appoint an amicus.
Yes, madam.
Okay.
And CD also received, my lord.
CD received. We can retain the case diary.
Yes, madam.
Or Mr. M. H. Chaudhary, the learned come.
Madam, I'm
We are
appearing,
on- we are
I'm appearing on behalf of Mr. A. Ahmed, my lord.
That's what I'm
Yes,
searching
madam.
your
He's
name.
in Lexington court number 11.
And Mr. M. H. Chaudhary, the learned counsel for the petitioner, learned counsel appearing on behalf of Mr. A. Ahmed, the counsel for the petitioner. And also heard Mr. T.P. Goswami, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Goswami that as per his instruction, the service is already completed on the respondent number 2. However, no one had appeared on behalf of the respondent number 2. Accordingly, I find it necessary to appoint an amicus to represent the respondent number 2. Accordingly, MS B. Chaudhary is hereby appointed an amicus. Registry will do the needful. CD is already received. Retain the case diary till next date of listing. List accordingly, yes. Here comes the main issue about the date.
Only difficulty is that the case diary is pending since long. So investigation is also halted. So only considering that aspect, and I am also lordship in because of this case is pending. So because considering those aspects, because our side also and PP side also. So short date may be given, lordship.
That's what I'm saying. Date is the main issue.
That is the difficulty. Next week, any date?
Next week, we don't have any date. At best 15, next week, we don't have any date. Very sorry to say. Because what is happening, all are insisting for date. Advocates, and this is quite normal. And most of the dates are, in most of the cases from first to at least most probably till 13, 14, even 15 also. Above 20, 25, 30 matters are there. So fixed matters are there. So apart from that, motion matters will be there. So it is not in a position to fix the matter. That's what. So at least 16%. 1/6. 1/6 will do. We are retaining the case there otherwise.
Obliged.
May it please your lordship.
Yes.
In this court, honorable court granted me interim on 25/3/2025. I have appeared before the IO lordship and recorded my statement lordship.
Yes, lordship.
CD has come.
They appeared as statement recorded, lordship. But he is the driver of the vehicle as per his statement, but they are intent to a stemma was, or a religious meeting was going on, and they are lordship to stolen some mobile phones. And while stealing that mobile phones, lordship, they were caught by the public. And he was one of them. And he played mobile
stealing of mobile phone.
mobile phones. And a meeting was going on. Their intention is to store the mobile phones. And then they are 16 mobile phones are recovered from them, lordship. 2 persons were arrested. They along with these three were fled away from the place of occurrence. He was one of them. As part of his statement, he was the driver.
Numbers of mobile set were recovered from which place?
From their place of a meeting was going on at lordship. The place was it's called a religious meeting, Istema.
Oh, Istema was going.
Istema was going.
Istema where mobiles were asked to hand over or what?
No. They have stolen the conspired manner, lordship. All are paid over the meeting, lordship, and they have stolen the mobile phones. No, in the meantime, they got red-handed by the public. 2 persons were police arrested them, and 3 were fled away. One of them, he is one of them, lordship. Yes, that yes, appeared in
Then
statement.
recovery was there or
Recovery is there from that arrested persons also.
those from those arrested person? But this person, this person, petitioner was also
involved. He was the driver of the vehicle as per his statement, lordship. But co-equal statement said there, he is along with them, lordship. But their intention is to sold up a mobile phone, lordship. The intention is very clear, lordship.
Now, may I add my last point?
So you're in the Istema also you're
No,
not
yes.
giving
I hail from Hojai, madam. They have hired my vehicle, 2 persons. They join in the Istema. So, madam,
Istema is a religious thing.
Yes,
In that case also you have
those people are
spared.
pickpocketed the mobile, those 2 persons. And those 2 mobile were recovered from them. I was in my vehicle, madam, as a driver, to take them back. Then in the end, they were caught by the public and handed over to the police. Out of fear, I did not go to the police station. Later on, when your lordship had granted me interim bail, I appeared before the IO and recorded my statement, and my vehicle was also released by me.
Statement is recorded.
From where you have got the vehicle? From police station?
From police station. Out of fear, when they were taken to police station, that out of fear, I have left the place. But I have got no role. I am not in operation from this.
Mr. S.C. Biswas,
Well, her name may be
Okay,
J.
sure.
Ghosh.
Yes, MS?
J. Ghosh.
J. Ghosh. Oh, sure. Now, otherwise, she was.
Yes, she was asking me to, then I will submit.
Okay, very nice. And we also want to hear the.
Yes, sure.
Okay, heard MS J. Ghosh, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application section so and so in connection with so and so. CD receipt, Barrister Singh. It is submitted by Mrs. Ghosh that the present accused petitioner is innocent and he is no way connected in the LS offense. He was merely a driver, and on the date of incident also he was in the vehicle. But out of fear, he could not appear before the police station when his passengers, some 2 passengers, were already arrested by police. However, after getting the order of interim bail dated 25/3/2025, he already appeared before the IO, cooperated in the investigation, and he also got the Jima of his vehicle. So he is still ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of pre-arrest bail. Next from Mr. Goswami, the learned additional PP submitted in this regard that the petitioner appeared before the IO, and cooperated in the investigation. Full stop. However, from the materials available in the case diary, it is seen that the present petitioner was also involved in the alleged theft and alleged theft. Full stop. But all the mobile handsets were already recovered by police during investigation. Next paragraph, we did consequence. Okay, you are granted with bail. 25/3/2025 is your made absent. Okay. Item 33 we are taking. CD is not received. Issue reminder will deliver.
38.
Milk, please.
Yes,
In
yes.
terms of your lordship direction, we appeared for the interrogation twice before the twice I have appeared for the interrogation. My friend has joined recently for CBI. Well, I pray that this matter may also be taken up on 14.
No, 14, there are lots. Somehow we accommodated in that matter only
Your
on
lordship
14.
kindly give a date. My friend is also joined recently. Your lordship give as per your convenience. I'll not bother because since I'm on interim, I can wait. Madam.
You are in interim and you have
Yes,
already appeared.
Thrice.
Thrice you have appeared.
So now it is up to the lordship, which date.
Any date
But
convenient.
it is in the hearing column where you received the case diary or whatever, I don't know.
CD we have brought.
CD you have received.
CD is there, CD line.
CD you have not received.
No, yes.
You
yes,
received.
yes. If your lordship want, I can submit the CD today.
No. At the time of hearing, only after that, only I accept. Heard Mr. P.D. Pond, learned senior advocate, assisted by
Miss S. Bhuyan.
Miss S. Bhuyan, and also heard MS M. Kumari, the learned. You are appearing as a deputy SGI or
No.
on what stand?
A retainer council of the CBI, recently appointed.
Which is a retainer
last
council of the CBI. Post-op. It is submitted by MS Kumari that the CD has already been received, but she needs some more time for perusal of the same. Next paragraph. Mr. Ford, learned senior advocate, submitted in this regard that in person to order of interim pre-arrest bail, he has already appeared before the IO in three occasions, in three occasions, and cooperated in the investigation of this case. Next paragraph, considering the submission made by learned counsel for both sides, let the matter. But one thing is that you may return because case may be fixed either 16, 17, because prior to that we are fully
16 or 17?
Maybe.
May. 16, I may not be there. Sir.
Okay. Officer K.T.S. 20. 21-5.
Yes.
In that case,
21.
you return the case diary and then it may be asked by your petitioner to
21st of
21st. Yes, on 21st of. CD may be returned asking, calling for the updated one. Okay then. By that time we can update it.
Interim order will continue till that.
Interim order be continued till next date of listing.
It's good to have Madam. She has 16 years of experience as a CBI counsel in the trial court.
Oh, earlier to that.
Yes, earlier I was in the trial court.
Trial court, no?
As a special counsel.
Then she went to NCLT as a member.
NCLT, I know.
Yes,
She has been to NCLT.
In the year 15-16 as a judicial member. First posting Kolkata, then Ahmedabad, then demoted office as a president of the NCLT, completing the tenure.
Will be utilizing her experience as a to have 16 years as the CBI counsel is a long
Yes,
period.
obviously. Long.
It's all there. Bars cooperation and bench cooperation. We can't do anything alone. It's
Obviously.
a composite work.
Obviously.
God bless you.
Okay.
Much of it.
39.
So probably service is not completed.
Service not completed, Lordship.
It was
Service is still awaited.
Lordship, CD also not received. In the meantime, we have taken instruction whether service is completed or not.
Heard Mr. Your Mr. A.K. Azhar. Heard Mr. A.K. Azhar, the learned counsel for the petitioner. And also heard Mr. D.B. Goswami, so and so. Office note dated 23/4/2025. It is seen that the service is still awaited for the response number 2. Also, however, it is submitted by Mr. Goswami that he will take instructions in regards to the service of notice on response number 2. CD also not received, issue reminder. List the matter accordingly. Yes, Goswami, we don't have any date. 19.
19, it will so long, there is no interim order possible.
What to do? We don't have any date. In fact, very problematic for us. We are facing very much problem. 19.5, you are not on jail. You are not inside the jail.
Not
let it
inside
be on
the jail, but supposed to.
Oh, you are supposed to go there. Okay, then very nice. Go inside the jail. Now you have every facility. Will get there. Okay.
No interim order, thereby I am much obliged.
Don't go. Don't go behind the jail.
There's need to some protection.
So this is an POXO protection generally cannot be given.
My lord.
What you have not received a case diary, Lordship.
40?
May I
You have received the case diary?
Not received the case diary.
Lordship, I have filed an additional affidavit
Mm.
to bring into record my registration certificate to run that business, Lordship. Which inadvertently I had left in my daily application, no, Lordship.
The annexure 1, page number 18.
Yes, Lordship.
Yeah, you still did not received here.
Not
You have
still
not
not
received.
Lordship, I may be protected, Lordship. My humble
so-
submission, Lordship, is that I run my business in a small area, Lordship. It's a remote area wherein from the villages also farmers come in and sack of rice directly I purchase from the farmers. So, Lordship, in that way, I don't have invoice when I purchase from a farmer. So this is the reason, but while I had sold these bags, I have proper documentation, GST bill, everything I had, and I have provided.
So otherwise cases that you have, what you're not paying the GST or what? What is the allegation in fact?
Allegation is that the PDS rice.
Whether it's PDS right there,
PDS
that's
rice.
started.
But it came directly to my shop. Lordship,
How PDS rice can come?
I don't know whether it is PDS rice. Huh?
Actually, as per
People come and sell. Beneficiaries sometimes come and sell. They don't eat because in that locality they eat boiled rice. But PDS rice usually it's not a boiled rice. What is provided. So the beneficiaries they sell. So that also I purchase. So in that way, Lordship.
240 bags. Per bags 50 kg.
And
These are
PDS
boiled rice? No.
Lordship, nowadays everything is digitalized. But directly it goes to the beneficiaries, and beneficiaries has to give their thumb imprint. There is a system is there, and they only will directly receive that food grains according to the ration card holder. If there are 5 members, they will get 5 kgs per person. So but in my locality, most of the people who are entitled for this food grains, they take the rice and they sell it off. One reason is that this is not a boiled rice. And in our locality, most of the people, they eat boiled rice. So this
But your registration in the GST registration is also when? It was registered?
1221, Lordship.
21.
Yes, Lordship.
But you're running this shop since when?
And I don't have any knowledge whether this is a PDS rice. People comes in, they sell 2 bags of rice. So I purchase it and then I sell it. Included farmers also come in to sell that rice. So Lordship, in that way.
FI 14 Lordship, case 14 Lordship. Accordingly, I arrived at PO on mere suspicion as employed as per Section 10 of Essential Committee Act 1955, and on checking the vehicle, it is seen that a truck was loaded with 240 bags of suspected to be the PDS rice, having approximately 50 kgs each bags. On questioning the driver, he failed to provide any satisfactory reply regarding carrying the rice in his truck. Later, he produced one cash memo in the name of MS Afrin Store. Serial number 73, and this is the
yes,
Lord. 2 numbers of tax invoice 6 in the name of MS Afrin Store, serial number 50 and such and such, but seems to be doubtful. So, Lordship, whether it is a rice, PDS rice, there should be a certain from the case there, it will be reflected for the case, whether it is PDS or not.
Lordship, and in fact, Lordship, I don't know because I purchased from even from the.
But it is if you have submitted that, sometimes the farmers come to you
Yes.
or directly they
Yes, Lordship.
sold the, but 240 bags of rice, I mean.
I run a grocery shop. So I have, along with rice, I sell other pulses and everything that I have stated also in my.
That is okay. But how 240 bags of rices can be there loaded in the truck from your?
Because not only one day, Lordship, I run a business and every day also I purchase from the villagers. And when there is a
hut in the local areas, what happened? Hut is there. If from that local market also I purchase rice. From local market where direct farmers comes in that market, from there also I purchase rice.
It is a submission, case there is complaint.
Lordship, at least I may be protected. I'll cooperate with the investigation, Lordship.
I don't think it is a case of protection. In fact,
Lordship, my humble submission is because CD also is not received. On the last occasion also, this is the second time, Lordship, CD is not.
Why CD is not? We have not.
And it's Gochuk, Lordship, Guwahati only, Lordship. Gochuk, come to Metro.
Why CD is not received from Gorchuk only?
We have communicated, Lordship, on 21/4/25, Lordship.
Lordship, I humbly submit. At least I may be, whatever conditions is level, I will abide with all the.
Okay, short date will give it. Trying to give. In fact, 14, heard MSD host, Learned Counsel for the petitioner, and also heard so and so. It is submitted by Mr. Goswami that the CD not received. In that context, MS host submitted that this is the third time when the CD is not received by the court, and accordingly she insisted to give some interim protection to the present petition. Next period, considering the submission made by Learning Counsel for the petitioners and Learning Counsel for both sides, let the matter be listed. Yes, when it can be called for.
16th of May, Lordship.
16th of May, it will be too late for you. Too late.
Too long, Lordship. I humbly pray, Lordship.
13/13/2025 with a direction to the IO to furnish the case diary on or before the next date listing. In default, the IO may be served with a personal so cause notice. Further, Mr. Goswami, the learned additional PP, also hereby asked to make communication with the IO for furnishing the case diary list accordingly.
Lordship is second time today. First, I moved on
Second time.
7/4. So 21/4 it was fixed. CD was not there, and today is the second time.
Second point. Okay.
Deep tube line.
For orders, item 41.
Mr. Das, you are appearing for? Is it?
Gosala, Lordship. There is one.
For Goshala,
Lordship,
there are some cows, no?
Lordship, may I make a submission, Lordship? Prior to filing of this application, the present respondent number 4 has already approached the learned districts as Karbi Anglong, Lordship. In respect of the order that is being agitated herein, the appeal is pending, Lordship. This submission I have been making since long, Lordship.
Oh.
That's why I am saying, Lordship, they have also appeared in there. I have the copy of the order also.
The respondent number 4.
The petitioners herein. The respondent number 4, they were given the custody of the cows by the authority, Lordship. Not the
No, who approached, who preferred the appeal? Respondent number 4.
Respondent number 4. That appeal has already been admitted, Lordship.
Respondent number 4, why she approached against which order?
Lordship, the impugned order giving them the custody and giving them the acquittal also. Because the Prevention of Cruelty to Animals Act provisions were there, Lordship. So being the animal welfare organization, they have the locus to silence those, as per some Supreme Court judgment and the High Court judgment also. That appeal is pending. And the present petitioners are also have already entered appearance there. Lordship. I have all the certified copies here.
My lord, my humble submission.
So better, why I'm submitting, Lordship, instead of fighting here, Lordship, if they go there and settle up, face the trial, face the appeal, in fact, and if anything remains thereafter also, if suppose the appeal is allowed or appeal is dismissed, then the consequent petition will follow thereafter, Lordship, because the alternative remedy and this petition, Lordship, I'm just pointing out, Lordship, this petition was filed on 23/9/22, and that appeal was filed on 7/9/22, Lordship.
This petition is filed
on 23/9/22.
And appeal?
Appeal was filed on 7/9/22, Lordship. And Lordship, one of the orders, Lordship, it has been reflected, Lordship, that if I may read the order, Lordship. This is an appeal filed by the Gosala praying inter alia to stay the order of the release of the cattle passed by the learned SDGM, hard MS so and so, and MS so and so, the learned PP. In this case, the accused, since equity, the accused means the petitioner's hearing, are represented by Mr. So and so, LADC. The Gosala has claimed a maintenance amount of for keeping the cattle during the period of investigation and trial, and having heard the parties, I have told, I hold that a reasonable amount may have been spent by the Gosala for maintenance of the cattle. However, what is reasonable amount cannot be decided by this court. Therefore, in the interest of justice, the parties are asked to appear before the DLSA, and the secretary shall make an attempt to negotiate the settlement. Send a copy of this order. This is the order, Lordship. It's long back.
This order was passed by
Passed by the district judge, Karbi Anglong, Lordship. Because the main, there are two grounds, Lordship. One, while deciding while dealing with the case and dealing with their acquittal, the other part, the cruelty on the animal, that has been overlooked by the learned trial court. On that ground, the Gosala approached the learned district judge, Lordship. And there, in the meantime, the Gosala, there were some submissions from the side of the Gosala that because Lordship knows it very well that some provisions are there under the Prevention of Cruelty to Animals Act for maintenance. Because the Gosala did not go of their own to have the cattle. They were given the custody by the authority. So they spent considerable amount of money for maintenance. That's why they were seeking the maintenance also, and along with that, they are challenging the other side, overlooking the cruelty part. And
so but when the order was passed by the district judge, you just read out the order. There, from there, it reveals that the Gosala admits that I mean, there is any factor that that what is the order of challenge is that
no, that is not the actual Lordship. This is the recital of the order. But the appeal memo says otherwise, Lordship. I have the entire.
No, only what basis the district judge passed the order that negotiation has to be there
Lordship,
before releasing the cows. Is there any such kind of order?
No, Lordship. It is still pending. Now it has been kept in abeyance because of the proceeding, this instant proceeding. The appeal is kept in abeyance.
Yes,
there.
Kept in abeyance. But the question is that there in the order, district judge passed an order.
Lordship.
Where the authority, I mean, district legal services authority was directed or asked to make the negotiation in regards to the amount which has to be.
But that failed, Lordship.
That failed.
They appeared. They the amount. There was some subsequent order also that detailed order was not uploaded, so I could not bring, Lordship. Why?
But now the question is that at this stage, whether the Gosala is ready to hand over the cattle.
No, the main proposition of the appeal is still pending regarding the cruelty part. In the appeal before that is yet to be adjudicated by the learned appeal.
No, but you do want to say that regarding if the cruelty part is still pending while dealing with the case and the appeal part is there.
Yes.
So that was not that was overlooked or whatever.
Yes.
But my question is that part is already there. Yes. Can we understand that the appeal is pending? The challenging the order of so and so, the positive relative part was not considered. But my question is that whether at this stage Gosala is ready
to hand over.
That is the question, because order of handover is there. Well, earlier there.
Also. But
have you challenged the order of handing over the?
Yes, also including entire order also, entire judgment.
No, in one hand you are challenging the order of suppose handing over.
Yes.
On the other hand, you are saying that you are ready to negotiate the amount.
The thing is that the original pleadings that I have seen in the appeal memo, this handing over and negotiation part was not there. There were some probably in between some submissions from the other side also. The original pleadings did not does not contain all this negotiation part also. It was.
Can I ask you one thing? Then it is now see this writ petition is pending since 2022.
Yes.
On same subject as you have challenged that the order of the handing over was in spite of that you are not handing over. Yes. Respond number 2. Sorry, respond number 4. So can you take some kind of instructions from the respond number 2 if they are ready, suppose anyway? Then matter maybe, but otherwise, yes, appeal is there. Appeal you may not be, you may take the ground of cruelty and whatever there is appeal. But regarding the handing over, is there any possibility?
If the cattle are handed over, Lordship, then the Lordship.
The appeal will be infractions.
Yes, Lordship. That is the thing. Lordship.
My humble submission, my lord. My learned friend is submitting something which is not connected with this exact fact of this case. Case is that, my lord, we were arrested on the basis of the FIR that we have stolen some cows. But we are the owner of that cows.
And subsequently you got acquitted.
We got acquitted. The court ordered to the police that after acquittal, since they are the owner, you hand over the cows.
Yes.
On the basis, accordingly, we have submitted the order to the police. Police went to the authorities where they kept the cows. They are not giving this cows. So their issue is that they need compensation because they have taken this cow for some considerable period of time. They may take this compensation from the government. We are the owners of the cows, madam. We cannot provide any compensation. This is not the issue. Issue here is that they are violating the court orders. And that they are not the authority to decide who have to pay compensation. This is not what exactly done. It is their duty to hand over person to the court order. But they are violating the court order repeatedly. They have challenged this order by way of an appeal, whatever. Their issue is not to keep this cow. They cannot take this cow, keep these cows for a considerable period of time. They must hand over these cows, person to as per law. And if they are agreed with any compensation, they may approach before the government authorities. Yes, we have nourished cows for a period of time. We need some compensation. How they kept this cow for an indefinite period, my lord? This is the question here. This is why we read petition criminal. This is why before your lawsuit, madam.
But there will be some contradicting things
Lots of-
there because appeal is filed by the respondent number 4, challenging the order vis-a-vis the order of this release of cow.
Yes, Lord.
The entire matter is there before the appellate authority. I think so.
Yes, Lord.
So in that case,
If the record is there.
The record is here.
Record is there. My record may be called for, my lord. This is not exactly what happened. My humble submission, my lord. They may take compensation from the government. How they kept my cows, my lord?
No, Lord, sir, my friend is not going to the core of the issue. With all respect, Lord, sir, the prayer part of the appeal, the entire judgment has been silenced, which has been which they are referring to hearing 5/1/2022 and 21/1/2022, Lord, sir. Entire judgment. These are the whatever has happened, Lord, sir, this was the initiative taken by the learned district judge there. So making an attempt whether this can be settled. But that did not settle, Lord. So now the issue revolves in the appeal, main appeal, Lord, the entire prayer. And the appeal was filed prior to filing of this petition, Lord. That's why I'm saying, Lord, whether to both the parties may be directed to appear before the learned appellate court.
This is not the way, man. This
is the way, Lord.
This is not
the alternative remedy has already been taken by one of the parties, Lord. The writ petition, Lordship is deciding on an extraordinary jurisdiction. The statutory provision has already been exercised and the appeal has been admitted, Lords. And they are taking part in the appeal also, Lords. Prior to, and they have never uttered a single word in the High Court, nor they have enclosed any of the documents. I have
now, as per you, what is the stage of the appeal?
Because of the pendency of this appeal, because the record has been called for, Lordship, it has been kept in abeyance.
Original record is called for.
Scan copy probably, Lordship. Scan copy.
Then is there any order of stay also? No.
No, Lordship.
No, my lord, no stay order.
Then
original.
Original one. Why original was called for? Where is the order? Calling for the LCR?
They have no locus to, my lord.
We have the locus, Lordship. We'll raise before the learned.
They have no locus to challenge the acquittal order. They have no locus, my lord. It is a long hearing is required, my lord. If necessary, my lord, I will.
Achha, record was called for, no?
Yes, ma'am.
So original case record is before
Is
us.
there.
Yes, Lordship.
So, my lord, your lordship may decide.
Then obviously it will be kept in abeyance, I
It's,
think.
naturally, Lordship, it is kept in abeyance, as I have been told, Lordship, this morning.
Then
Lordship, I'm making a humble prayer, Lordship. Instead of keeping this matter pending, both the parties may approach. That will expedite the otherwise expedite the matter because the parties have already approached. The appeal is at the stage of hearing now. The question of locus or anything that will be answered by the Gosala respondent number 4 there before the district judge, Lordship. And the Gosala has whenever in the cases where the prevention of cruelty to animals act provisions are there, Lordship, Gosala have the jurisdiction, Lordship. I have, Lordship, with all respect, I have done many of the such cases, Lordship. One of the cases has judgment given by this honorable court has been upheld by the Supreme Court also, Lordship.
My lord, in this aspect, I am not, I disagreed of my learned friend that the Gausala has the locus to file this case or file the appeal or something which they can hold the cows and cannot hand over to the persons, the owner of the cows. In this respect, my lord, I may ask another dress, my lord. They have no locus, my lord. I can submit, my lord.
Then
Let me fix any other date, my lord.
Then what will happen to the fate of this appeal, Lordship? Then it has been
They cannot, my lord. They have no locus. They suddenly came and praying compensation. How can they, my lord, challenge the acquittal order, my lord? It was challenged. It was, my lord, trial was conducted by the trial court. We got acquittal. They ordered to hand over the cows because we are the owner, but they did not hand over. How they are violating the court order, my lord? They're violating even directed the police visited there, but they did not have, but they are saying compensation. If anything they found, they may claim from the government, pursuant to the Prevention of Cruelty Act, madam. How can they hold the cows and paying compensation from us, my lord? This is not beyond the law, my lord. There is no jurisdiction like that. We have studied, my lord. If at all this is the point, my lord, we may act in another day. We may place our submissions, my lord.
No,
I don't know if it's any other
See, he is also a point because you are only the person who was given Jimma of those cows.
Lordship.
Cows. But how you challenge the order of the acquittal?
No, Lordship, the order of acquittal and the releasing of cow, it comes in the same order, Lordship.
No, how? On what basis you have challenged the order of the acquittal?
No, the entire thing has been challenged before the cruelty part.
On the what basis? On what
Cruelty
basis?
part has been overlooked by the learned trial court, Lordship. Cruelty
But
has
is it a
been.
duty of this foundation also?
No, Lordship, the cruelty, as an animal welfare organization, this Gosala is a registered animal welfare organization, Lordship. So under the animal welfare organization, they have certain supervisory.
Cruelty, when cruelty was occurred, when they were loaded
they-
or
they-
they were carried,
Yes,
at that time there was some cruelty.
Yes, Lordship.
Cruelty to the animal, it is all right. But under what locus standi you filed the, you prefer the appeal against the order of acquittal?
Lordship, whenever the learned, any court, Lordship, having there been the prevention of cruelty to animals act provision, if that has been overlooked, having there been material on record, Lordship, please, if that has been overlooked, the Gosala or any welfare, animal welfare
Can prefer.
Yes, Lordship. That certain judgments are there, Lordship.
Okay, then we hear to the matter then.
Case was registered under section 379.
No, Lordship.
Trial was conducted under section 379.
No, no.
Yeah, the
We
cruelty
got
to
it.
animal act was not there.
Yes.
That's why
Now
I'm saying he's not making the actual submission. Section 11(1)(8) of prevention of cruelty to animals.
That we have studied, my lord. They have no locus at all.
Lordship may keep them at their partner. Both the parties will satisfy that.
Part should not be there because I don't know up till 9 I'm here. Up thereafter I don't know part. So better not to keep as a partner. But I'm insisting you both the parties to make a submission, keep ready, and we'll hear the matter. That's what. If my bench is available till next date of listing, then obviously we'll hear.
Yes.
And otherwise, so that's why I'm not keeping it a part. That's what I'm saying. Or written argument also you can submit in that case if it is possible. I mean, case is quite interesting in
Yes.
fact.
Very interesting, man. How they are saying that we have done well. Very interesting.
Heard Mr. H.R. Chaudhary, the learned counsel for the petition. Also heard Mr. Ditul Das. Your how will you write yours?
Ditul Das was.
No, Ditul Das is okay. You are appearing as
engaged counsel of respond number 4 also.
engaged counsel for the respond number 4. Considering the submission made by learned counsel for both sides, I find it necessary to hear the matter at length, and accordingly, the next date is accordingly a need required and please for happening to attend your miladible. No, I do the request for video, for 10 more in the meantime, both the parties may file their written submission, if any. For reply date to you. Now see, we going to fix it in 21.05, 21.5, 22. 22 is a hearing day. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. 22 is a hearing day, so we're going to fix it on 22. Otherwise, how is their cows are already
They are
yes,
it's alive,
alive.
alive. Lordship.
Alive.
They are taking good care of the cows. Lordship. Lordship, I'm associated with many animal welfare organizations. So I have the instruction. I have done some sort of study also, Lordship, with all respect to animal cruelty.
Indeed, if there is any animatic cruelty to the animal in my personal view also, I also definitely against this seat because I'm also an animal lover. That is true.
My learned friend may take care of human being also.
No, Lordship. No, Lordship, I just off the record, I'm saying this is a bigger racket, Lordship. Well, once we fought 2000 during the lockdown period, Lordship, 2019, 20, 21, Lordship. Oh, I have seen this word, Lordship. This is a bigger racket. I personally received life trade also, Lordship. I worked for Dhyan Foundation at that time. Still, I am working with them. But I received life trade because I got so much involved in that.
Oh. Oh.
It is a bigger market than the narcotic market.
But that submission is not part of this.
No, that's what I'm saying. I'm making off the record.
Off the record, off the record. He is submitting off the record. Your petitioner is. That's why you got acquittal also. Let us see what appellate authority give, that is other aspect, but otherwise.
Okay,
thank you.